Vietnamese interpreter?
Actually, we don't need a Vietnamese interpreter. Actually, I requested to cancel. I apologize if it was not early on. Sorry.
Okay, so you don't need me then?
Correct.
Okay, thank
I
you.
apologize. Thank you.
Okay, bye-bye.
Ms. Bridgewater, I wanted to see about the add-ons. I had Starworth with two add-on cases. Is there three? I think you said three.
Yes, there are three. There was a add-on to the add-on.
Let's see.
Same defendant, all three cases have the same charge.
That is
What
correct.
I'm showing. Do you need me to send it to you, Judge?
What's the name that you have in position 25 is Wilcox?
Yes.
Looks like I may have printed the same thing twice, and then I have an add-on 1 and 2 with Starworth. If you have a third.
Yes, he has three charges.
Right.
Three cases.
Different days, same theft of services cases, but just different offenses.
Send me the third one and I'll print as we go along.
Okay.
All right, I'll go ahead and get started and then send me the third. Good afternoon, ladies and gentlemen. My name is Judge Regina Mincy, and we're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we are able to address several matters, including bond, possible arraignment, and a possible plea offer if one has been made at this juncture. I'm going to begin and advise everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube, so govern yourselves accordingly. I want to also remind the defendants on this calendar that you have certain constitutional rights. The first being that you have a right to have counsel and representation with you at this juncture of your case. Most of you should know who your attorneys are at this point. You also have a right to remain silent. Anything that you state about the facts, circumstances, and the occurrences can and will be used against you. So listen to your attorneys again. Ms. Bridgewater, what is our SAP reset date?
March the 21st.
And Your Honor, we have an attorney, ASG Naomi Campbell. She's indicated she's waiting out in the Zoom waiting room, and she is presenting on 9 of the cases today.
Who is my Zoom master?
It's Miss Strong, and I don't see anyone in the waiting room.
Okay, I'll have her check the Zoom link. Thank you.
Your Honor, whenever you're ready, we have position number 15, Miss Angela Magby in front of me.
All right. This is case number 23 CR 001250E, Angela Magby. You're charged with 1 count of simple battery, family violence. The offense date is March the 5th, 2023. Pretrial.
I'm only showing one prior arrest from 2012 for a false report of a crime. There was no disposition listed.
All right, thank you. State.
Good afternoon, Your Honor. This incident did occur yesterday at 3793 Leesburg Court Southwest. The victim in this case is a juvenile with the initials JS. In this incident, the victim, who is juvenile JS, indicated to officers that her mother called her into the living room, who is a defendant in this case, to talk to her about a previous defects incident between the two parties. She indicated that her mother called her a traitor for calling defects on her, and then began to attack her by dragging her down the stairs, pulling her hair, slapping and striking her while also doing the same. There was another minor there, the victim's brother, who attempted to jump into the altercation to break up the altercation. Eventually, he was successful in breaking up the altercation, and police were called by the brother, and they took the mother into custody in this instance, Your Honor. The state does have concern about risk of reoffense, given that it's indicated that there is an open defects case between these parties. Our victim advocate was not able to talk to anyone supervising or having guardianship over the victim in this case, since she is a minor. However, she did email the facts to see about more details related to their open case. However, we don't have those details at this time. The state is going to be requesting a $3,500 surety in this case, because the victim is a child and there is continued issues with Department of Family and Children's Services. We were asking for no further contact. The victim in this case did indicate that her mother had been drinking all day, and that's how this incident occurred. However, we don't know if there is anybody else who can watch the juvenile victim or the other juvenile that lives in the home with the defendant. So we will defer to the court, but our position would be no further contact, given that there's continued possible abuse in the situation. We'd also defer to the court in terms of a stay away. And if there are open conditions as far as defects is concerned, we'd ask that this defendant have to follow those restrictions placed by defects. We'd ask for 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law.
All right, PD Kim.
Yes, Your Honor. Miss Magby is 49 years old. She was born and raised here in Georgia. She has 2 minor children. She has been a stay-at-home mom for a long time. And yet last Saturday was her first day at the working station concession stand. She got a part-time job at Premier Staffing Company. However, she's afraid that she may have lost that job since she couldn't go there today. Other than that, Your Honor, she has not had any working experience until for a while. She was a stay-at-home mom. She graduated from high school. She used to work at UPS a long time ago, and she does not have financial means to pay for the bond. Indeed, she's qualified for public defender services. So our team will continuously represent her for this case. She claims that it was not battery / family violence. It was more like disciplining her child. So we would like to request for signature on bond through the jail or pretrial, so she can go home and take care of 2 minor children. Thank you.
We would just like to iterate that the victim indicated she was dragged down the stairs, her hair pulled, she was punched and slapped during this attack by her mother. Nothing further.
So we don't know where the children are at this point, or we assume they're in defects custody.
Your Honor, I do not know where the children are at this point. Our victim advocate did try to reach someone, but we weren't able to make any contact with anybody.
Ms. McBee, are you raising your hand to answer where your children are?
Yes, ma'am. They are with their father. They left the same day of the incident. Every time we have the incident, he takes the kids, keep them for a while and brings them right back to me.
Okay, please, do not say anything else. Thank you very much.
Let me ask one other
Sure.
question. How old are these children?
14 and 15, Your Honor.
14 and 15?
Yes.
All right, so it appears the children are with their father. I'm going to order a $5,500 signature bond through pretrial per judge. I'm going to order that there be no drugs, alcohol, or weapons while on bond, except for any medications prescribed to the defendant. I'm going to order the one-day anger awareness course through pretrial. And I'm going to order no further contact with the victim and the witness, I guess, or they're both victims, 2 minor children, JS, and I did not get the initials of the other child.
JS.
It's JS as well.
Oh, both are JS. Okay. No further contact with the children, and to obviously continue on any restrictions according to the defects case or rules that they may put in place. I'm going to, and I'm hesitating about to stay away from this address. And what I will do, Ms. Bridgewater, is say that the defendant will only be able to return to that address as long as the children are not there. Seems like they're in the custody of their father. And I'm assuming that will be for a minute while DFACS conducts their investigation. And as long as the children are staying with their father, there should be no contact with their mother right now while on bond, and she can go there. I usually have a law enforcement escort to go back to determine that, but I imagine the things of the children are going to still be there because they will ultimately live there. But I'm going to put that responsibility on the defendant, Ms. Magby, that if your children return there, you cannot live there. But as long as your children are still residing with their father and not at that home at 3793 Leesburg Court, you can stay there. Is that clear? Okay. And if for some reason they return or DFACS wants them to return, you cannot do that. You will have to go live somewhere else because you cannot be around them right now while you're on bond. Anything else, counsel?
Nothing further than that.
All right, thank you.
Excuse me, Judge, before we move on, is the attorney for position number 8 on the Zoom, Ms. Gingwa?
I don't know. Who's speaking?
Ms. Strong?
Ms. Strong?
Yes, ma'am.
The host for Zoom, I assume, maybe.
Okay, thank you, Judge.
Okay.
Your Honor, can I just ask, Mr. Michael Connor, who is he here for? Who is he representing?
Yes.
Mr. Brathwaite.
Okay,
Position 2.
he'll be coming up shortly. But
All
next,
right.
but next
Go
we're
ahead.
gonna position number 19, Ms. McLemore.
Okay.
Yeah, and I'm here for Miss McLemore.
All right. This is 23 CR 001255G Takara McLemore, charged with one count of criminal trespass. Offense date is March the 5th, 2023. Retrial.
12 cycles, 6 out of Georgia, 6 out of Tennessee. Open theft by receiving stolen property, 22 SC 183803. 2 probation violations, 2 FTAs. 2014 theft conviction out of Tennessee. 2016 theft of property and criminal solicitation conviction out of Tennessee. On probation for first offender probation for possession of cocaine with intent to distribute. Disposition was April of 2017. It was 9 years probation. I forgot to write down the case number, but it is out of Fulton County.
All right, thank you. ASG Young.
Yes, Judge. On March 5th, 2023, officers responded to 2770 Carmen on Wesley Drive, Northwest, here in Atlanta, due to a report of a criminal trespass. Officers made contact with the homeowner, Mr. Abdel Aleem. Abdel is spelled ABDEL-ALEEM, who stated that Ms. McLemore, along with a co-defendant, had been trespassed from the property on the previous day. They were last seen leaving the residence the day prior in a Dodge Charger. They returned on the 5th. A neighbor saw them and called the police and reported the incident, and where they had entered through the back patio door and caused damage to the kitchen door of this home. Based on what I was able to gather from the report, I'm unsure why they were at the home or how officers were able to subsequently locate them. It's unsure if they were found at the residence when officers responded. So the state is recommending a $3,000 signature bond through pretrial services. Stay away from the address incident and no further contact with the victim, Mr. Abdel Aleem. We were unable to make contact with him. His phone was going straight to the voicemail from what I was able to gather. We do have some concerns about the defendant possibly being a flight risk, given that she has substantial criminal history from Tennessee from 2004 to 2016, but that's all from the state.
All right. And whose case is? This is PD Melnick?
Yes, Your Honor, I'm sorry, was that Jonathan Jackson?
No, this is position 19.
Okay, so I have the codefendant.
McLemore.
I have the codefendant.
Oh, you have the, okay.
This was, I believe, this was conflict case, Your Honor, and conflict attorney was on the screen, and then I don't know what happened.
Oh, I did see Ms. McLeod. Attorney McLeod. Attorney McLeod, she's still signed in. She must have stepped away. Didn't know she wasn't listening or not there.
You want to just come back to this case?
Yes, I guess we will. As soon as we do that, she'll probably pop on, but let's
Probably, but we can keep it moving though.
let's keep it moving. Thank you.
Right. Next, we're gonna have position number 2, Mr. Brathwaite.
This is 23 CR 001260C. David Brathwaite, you're charged with one count of battery family violence. The offense date is August 16, 2021. Pre-trial.
I'm showing 5 cycles, 4 out of Georgia, 1 out of Texas, with 1 conviction from 2019 for driving while license suspended or revoked.
What was the first word that you said? 4?
4 cycles out of Georgia and 1 out of
Oh.
Texas.
All right, thank you.
You're welcome.
All right, state, ASG Campbell.
Yes, Your Honor. The facts are that on the date of August 16th of 2021, at the location of 1220 McCaslin, and that's spelled MECASLIN Street, apartment number 1510. Officers were dispatched to that location and they met with the victim in that matter, whose name is Gianna, and that's spelled JIANA, and her last name is Barnes. At that time, they actually met the defendant first, who advised that he had physical altercation with Miss Gianna Barnes. And at that time, the officers did do further investigation, and they learned that the parties had been in a relationship for the past 3 years and had lived together for the past year, and that the defendant came to the home to collect his belongings after Miss Gianna Barnes decided that they no longer were going to be in a relationship due to the defendant's short temper, according to her words. And at that time, she basically left out of the residence because I guess the defendant and her were in a verbal altercation after her telling him she didn't want to continue the relationship and she left to get a security guard. And when she came back, she noticed that several of her items were broken, including her TV, her iPad, and her iPhone. Then when she confronted the defendant about it, that's when the defendant actually shoved her, leaving visible bruising on her chest. She also advised the officers that the defendant has been violent towards her in the past. And so for those reasons, the state does believe that he's a likelihood to reoffend, and the state's bond recommendation is going to be a $3,500 surety bond, as well as no further contact with Miss Gianna Barnes, and a stay away from the incident location, 1220 McCaslin Street Northwest, apartment 1510, as well as anger awareness, nothing further.
All right.
Good afternoon, Your Honor.
Connor, good afternoon.
Mr. Brathwaite is 29 years old. He's from Atlanta, Georgia. He's a graduate from Clark Atlanta University. He owns his own business called Champion Auto Sales, which is a used car dealership business. All of his family reside here in Atlanta, Georgia. Actually, his mom and the victim are present today. They have both been to counseling for this matter. From my understanding, it was just a misunderstanding between the two. The items that were broke in the residence were Mr. Brathwaite's items. So he purchased these items, they belong to him. The victim is here. She would like to speak on behalf of Mr. Brathwaite. She has not pressed any charges or wanted to pursue this matter. She explained to me that he didn't put his hands on her. He kind of just moved her out the way so he could leave the residence. And she's here to further explain that if you would give her that opportunity to speak.
All right. Is the victim
she's present in the
Gianna
courtroom.
Barnes? Oh, she's at the jail. I'm sorry, I'm looking on the screen.
And I want to add to that, they have been in a relationship ever since this incident. So since 2021, they have been in a committed relationship since the incident. It was just an argument that happened between the two.
I see. The offense date was August 16th, 2021.
Yes, ma'am.
All right. Ms. Barnes, do you wish to address the court today?
Yes, ma'am.
Okay, let me swear you in first. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, you put your hand down. First question I need to ask you, are you in fear of Mr. Brathwaite?
No.
All right. And do you want contact with Mr. Brathwaite?
Yes.
And I understand you're still in a relationship with Mr. Brathwaite.
Yes.
Do you all have any children together?
No.
And you've been residing together since this incident date in 2021?
Yes.
All right. Anything else?
No, ma'am.
All right. Any cross-examination by the state?
Yes, Your Honor, just briefly. Ms. Barnes, do you recall giving a statement to the police that day?
I do recall speaking to them, but I don't remember what was said.
Okay. Do you recall telling them that the defendant had been violent towards you before?
I don't remember what I told the police.
Okay. Do you recall that the officer that responded was wearing a body-worn camera unit?
I'm not sure.
Okay. Nothing further, Your Honor. And
All right.
the state would just like to reiterate that when the officer arrived, he did observe bruising on her body, on the victim's body, consistent with her being shoved by this defendant. And his body-worn camera was recording, and it did document those injuries to the victim. So the state's going to renew its request for that surety bond. Nothing further.
All right. Anything else, Mr. Connor?
No, Your Honor, I just want to say that Ms. Barnes said that the defendant just kind of moved her out the way. It wasn't any physical altercation. And I just want to reiterate that the items that were broke at the residence were his belongings. So that's it.
He wasn't charged with breaking her items. He was charged with the battery. So
No, I understand that, but you did address that he did break items at the residence.
And I'm not going to hear from the mother. I think I heard you say his mother was here as well.
His mother is online. She does work for defects. She has gave them counseling since the incident on how to resolve their issues. So yeah, they have been in counseling every week since the incident, or every month since the incident.
Well, it's somewhat tough when you have an incident that happened in 2021 and we're now in 2023. Although I do understand the cycle of violence, and I want to make sure that the victim will be safe. But if she's been safe going on 2 years, I would like to believe that she is going to be safe and has been safe, and that there is obviously no intimidation going on for her to come and testify to the court today that she still wants continuous contact. I'm not sure why it took so long for him to be arrested after this incident. But I will go ahead and order a $3,500 signature bond through the jail. And with that $3,500 signature bond through the jail, I am going to order no drugs, alcohol, or weapons while on bond, except for those prescribed to him. I'm going to order no further violent contact with the victim, Gianna Barnes. And it seems like he would have the resources. I'm going to order a one-day anger awareness course. And I believe that is it, counsel. Anything else?
no, Your Honor.
All right, thank you. Nothing further. Thank you, Mr. Connor.
Thank you.
On, can we sound for Ms. McLeod, see if she's ready to go?
Yes, Ms. McLeod, Attorney McLeod.
Yes, Your Honor, I'm here. I'm ready to go.
We presented on your case and didn't realize you weren't there. I don't know if you're gonna want me to start all over. And that was on position.
19, Ms. McLemore.
Yes, is that your case?
It was my case, but I thought someone said they had appeared for her. I thought that attorney said that he was there for
Oh,
her.
no, he was there for Brathwaite, the first case, the one that we just had. He was there for position 1.
Yes.
We don't have a private counsel for 19. That
Okay.
explains why you left us.
Yes, because I thought he said I was here from Miss McLemore. So I said, okay,
Oh,
hire
okay.
counsel.
Yeah, sorry about that. He is Miss McLemore. You're still wanting the services of Miss McLeod, correct? Okay.
Yes,
I think
I'm
that was a
happy.
thumbs up. Okay.
Yes, I thought she had counsels, he said he was there for her. So I said, okay, she hired counsel. So I deferred to counsel, but I am ready when the court is to go on her.
All right. I'm assuming you're going to want us to start over, correct?
Well, I did hear some of it, Your Honor.
Did you hear some of it?
Yes, I did.
Right. This is 20. Let me just say this again. 23 CR 001255G. Pretrial set 12 cycles.
Yes.
Do you need to hear that? 6 in Georgia, 6 in Tennessee.
I heard that, Your Honor. I did
Okay.
hear.
And I think the Tennessee was from 2004 to 2016. And what about the state's presentation? Should they do theirs again?
No, Your Honor, I did hear a little bit of it also. And I did
Okay.
have the opportunity to speak with my client at length.
Okay. And so the state again is recommending a $3,000 to signature bond through pretrial. Is that correct, Mr. Young?
Yes, Judge, that's correct.
All
We
right.
don't have an issue with that, Your Honor. Signature bond is fine. My client tells me that she's an event planner and she had just gone with her friend to view this house because she was looking for a big venue for an event that she was having. And they just walked into the house because it had said on Zillow that the house was open for viewing. And that is all, Your Honor. And she does have 3 young children that she takes care of. The eldest is 11.
All right, I will agree to the $3,000 signature bond through pretrial per judge. Because I do want you monitored, Ms. McLemore. And they will explain to you what that means with pretrial. I'm going to order no drugs, alcohol, or weapons while on bond, except for those prescribed to you. I'm going to order that you stay away from, is it Carmia Drive? I did not write down the address, Mr.
It's
Young.
a Carmen Drive, Your Honor.
I'm sorry.
That is the address, I believe. It's Carmen Drive.
Oh, Carmen, and I may have heard it wrong. Can you give me that address again, Mr. Young?
Yes, Judge, it is 2770 Carmen, spelled Carmon on Wesley, or Wesley Common Spelling Drive, Northwest Atlanta, Georgia.
All right. And so, Ms. McLemore, we want you to stay away from that property. If you go back there, you will be rearrested. And no further contact with Mr. Adele Alim or Alime. I may be pronouncing that wrong.
She doesn't know him, Your Honor. She was just looking at the house.
Okay. Well, you can't just walk into houses, even if they tell you they're open. You should contact someone to make sure you're clear or covered to do that so that you aren't arrested for criminal trespassing. Okay.
Well, I want to say, Judge, that the house is actually listed on Zillow. I looked as for rent, and it would say it was an open house. I did actually check that.
And so this was the day of the open house?
Well, that was her presumption, and she walked in with her friend just to look around.
Well, you need to be careful. Be very careful with that and maybe make some contact with whoever is listing the house for rent to make sure that you have permission to go there so that there is no misunderstanding. That's just my 2 cents of advice on that. Is just to be careful going into an empty home if you've not made any contact with the owners or the landlord that's renting the home, so that they'll know that you have a right to be there. Okay. All right. Thank you. That'll conclude this case.
Your Honor, that was pretrial, SOB pretrial?
Yes.
Thank you. Next, we're gonna go to position number 3, Mr. Philip Calloway. And he has a visitor here that wants to testify on his behalf.
I'll see whether I entertain a visitor if it's not a,
I believe it's his father.
Yes, father.
I'll hold for a second. I may not allow that. Just depends on what I hear. This is 23 CR 001259Y. Philip Calloway, charged with 1 count of simple battery family violence and a 2nd count of criminal trespass. Then state March the 5th, 2023. Pretrial.
I'm showing 6 cycles, 4 out of Georgia, 2 out of California, 1 conviction out of California from 2019 for DUI and possession of unlawful paraphernalia, and nothing further.
All right. State.
California too, I'm sorry.
Oh, sorry. Okay. State.
Yes, Your Honor. The facts are that on the date of March 5th of this year, at approximately 10:28 in the morning at the location of 410 Saddlebrook Drive in Roswell, officers did respond to that location for a call for domestic dispute. They were met with the caller, who is the defendant's 79-year-old mother. The caller's name and the victim's name is Carolyn Calloway, and that's spelled Karolyn. Ms. Calloway advised that her adult son, the defendant, pushed her in the chest into a door, and he destroyed a picture stand that contained several picture frames. When the officers arrived, they did observe that that picture stand was broken. And I will note for the record that there were no visible injuries to the victim. However, after speaking with both the defendant and the victim, the officer did learn that the defendant has issues with substance abuse. They referred to him as a recovering addict from Suboxone, and that's likely what actually precipitated this incident. And it's my understanding that the defendant was living there with his mother, Ms. Carolyn Calloway, due to the fact that he was homeless at the time and had nowhere else to go. We have had contact with the victim. Per our victim witness advocate, she's not afraid of the defendant. She does want him to return home. However, the state is concerned that there has not been a sufficient enough cooling off period in light of the fact that this just happened yesterday morning, and the defendant did show violence towards his elderly mother, who's almost 80 years old. So for those reasons, the state's recommendation for bond is a $4,000 surety bond, $3,000 in a simple battery, and $1,000 on the criminal trespass. State's recommending no alcohol, drugs, or weapons while on bond, and alcohol, drug evaluation and treatment, considering the fact that both the defendant and the victim admitted that there is some drug use by the defendant, as well as no further contact with his mother, Carolyn Calloway, and a stay away from the incident location of 410 Saddlebrook Drive in Roswell. Nothing further.
Thank you. This is PD Melnick.
Yes, Your Honor. Did you want to hear from his father?
I don't know. Let me hear from you first, and then I'll determine. We have a full calendar today, so I don't want to belabor too much.
Yes, Your Honor. If you look at Mr. Calloway, you'll see, and if you read the report, it states that he was a victim of a hit and run about a month ago. Okay, medications are as a result of him having a broken leg, a broken back, and broken neck. He was convalescing at his parents' home. Everything else that they've said is really relevant because it really relates to the fact that he is convalescing and has been in extreme pain. He does work from home. He works for National Solvent Exchange when he does shipping and receiving and resending from them. So we'd ask the court for a signature bond on this case.
He's how old?
Let's see. Wait, it's right here. He was born in 92.
And Your Honor, just briefly, based on his criminal history alone, all of the prior arrests are for drug and alcohol related incidents. So the state is concerned about the drug use, even prior to his convalescing for being in an accident. So the state's recommendation is also based on that prior criminal history for drug and alcohol related offenses solely, nothing further.
May I say something, Your Honor?
You need to speak to your attorney about that. You may state some things against your interest. I do see, I've done the math here. You're 31 years old.
Yes, ma'am.
Okay. And so you need to speak to your attorney about that. I don't want you to make
No,
any
he is not
statements
going to make a
against your
statement.
interest.
Yeah, he's not.
This is not a trial. This is just a bond hearing. And so I'm not going to dive deep into the facts at all, except that what I need to know as to whether you will be returning to court and some other factors that I'll look at, but I don't really want to belabor or go into the facts of the case, okay?
Yes, ma'am.
That is not this forum. I am going to go ahead and give my ruling. I'm not going to hear from your dad today. I think that would be better suited for the next hearing or the trial of the case. And I appreciate your dad for getting on or coming down to support you. I'm going to order the $4,000 surety bond. I'm going to order no drugs, no alcohol, and no weapons while on bond. I'm going to order a stay away from the incident location. I was going to ask, and I guess your attorney can find out, do you have somewhere else you can go stay so
Yes.
that there would be the proper cooling off period?
Yes, Your Honor. He does have another. I did discuss this with him in case the court ruled this way. You stated for a proper cooling off period. Can he return because they are assisting him in? I mean, he had a broken leg and back.
Now, I heard those serious injuries. Well, I guess my concern again is that the victim will be safe in her own home. And I understand that he may be convalescing there, but I don't know, with maybe his pain meds or other medications are causing some of these issues, but I don't want them to happen again. So I'm going to order the stay away for now. And then if you need to file a motion to amend the bond conditions, we can do that, and no further contact with Carolyn Calloway for the moment. I'm going to also order an ADET and to continue with whatever recommendations for treatment that they order or recommend. And that's all I'll order at this time.
Thank you, Your Honor.
It did say, I'm so sorry, let me just ask for clarification, okay? Because I'm sure with his serious injuries that he's convalescing with, he is on medications. So I don't want them to say, I'm sure they're prescribed medications, I'm sure they're narcotics. I don't want there to be an issue with this. So.
Right, I did, usually what I'll say is no drugs, alcohol, or weapons except for prescriptions that were prescribed. Of course, not to abuse those prescriptions, but to take them as they are prescribed and obviously not mix them, I'm sure, with alcohol or any other drugs or substances. But with the ADET, he will have to obviously disclose what type of medication he is taking. But if there's other problems not related to the medication, but to any other substances that he may be taking, the ADET should be able to discern that. Okay. But Mr. Calloway, when you go for your ADET, you'll have to explain and take copies, obviously, of your prescriptions and what type of medications that you're on, but I want to make sure that the victim will be safe in her home, even though I know she may be helping you, but we don't want any more incidents to occur, okay?
Yes, ma'am.
All
And
right.
your, what is the breakdown on the bond amount since there's 2 charges?
I'm sorry, thank you. Simple battery, 3,000 and 1,000 on the criminal trespass for a total of 4,000 surety.
Thank you, Your Honor.
Thank you.
Your Honor, what was the breakdown again? I'm sorry.
3,000 on the simple battery, 1,000 on the criminal trespass.
Thank you.
Uh-huh.
And next, we're gonna go to position. I guess it's number 7, Mr. Ryan Garner.
This is 23 CR 001253G. Ryan Garner, you're charged with 1 count of criminal trespass. The offense date is March the 5th, 2023. Pre-trial.
I'm showing 24 cycles, 20 out of Georgia, 2 out of Indiana, 2 out of Illinois. I'm showing an open case out of DeKalb. That arrest date was February 8th of 2022. An open case for possession of meth, theft by shoplifting, and possession and use of drug-related objects, 20 SC 194563. Another open case for impersonating another in the course of an action, proceeding, or prosecution, identity fraud, suspended registration, and no proof of insurance, 20 CP 194563. I'm showing 4 FTAs. One of those FTAs is out of Indiana in 2019. A conviction for driving while license suspended, and then a 2019 conviction out of Indiana for unlawful possession of a syringe, and nothing further.
All right. ASG Young.
Yes, Judge. Here with Mr. Garner, the facts are the same as they were with McLemore, where they entered the residence on Carmen on Wesley Drive in Atlanta on March 5th. The state's recommendation is the same as for McLemore, a $3,000 signature bond through pretrial services. Stay away from the address and no alcohol, drugs, or weapon. And that's all from the state.
All right, PD Melnick.
Yes, Your Honor, there, the state, my understanding is asking for a $3,000 signature bond. We would ask for the court to go along with this ruling. This was listed on Zillow. It was an open house. It makes us all think about, before we go visit homes again on open houses. But so there was not, I think it was set for a trial, it was to save it for a trial, but I think the intent was there. So I think the state's recommendation is reasonable in this case.
All right. I will again, Mr. Garner, I'm sorry. Order that $3,000 signature bond. And I'm going to order that to be through pretrial per judge. I'm going to order to stay away from the same address for the open house, which was that 2770 Carmen Wesley Drive. No drugs, alcohol, or weapons while on bond except for those prescribed to you. And is this the same, no further contact with Mr. Adele Alimi?
Yes, Judge, just the same victim in this case.
Okay, all right. And I think that's it. Anything else, counsel?
Not this time, Your Honor.
Thank you.
Position 4, Mr. Chestnut.
This is 23 CR 001263F. Darren Chestnut, charged with 1 count of simple battery. The offense date is March the 4th, 2023. Pre-trial.
19 cycles, 16 out of Tennessee, 3 out of Georgia, one FTA from 2007, a 2018 willful obstruction of a law enforcement officer conviction that's out of Georgia, 2010 aggravated assault and assault conviction out of Tennessee, 2009 possession of cocaine conviction out of Tennessee, 2008 simple possession of marijuana conviction out of Tennessee, 2007 driving on revoked, cancel, or suspended license conviction out of Tennessee, 2005 DUI conviction out of Tennessee, and nothing further.
All right, ASG Campbell.
Yes, Your Honor. The facts are that on the date of March 4th at approximately 11:46 at night at the location of 6260 Peachtree Dunwoody Road in Sandy Springs, this defendant did start a verbal altercation at that location, which is the La Quinta Inn, with the front desk worker at the La Quinta Inn, whose name is Sydney, and that's spelled SYDNEY Fields. He started a verbal altercation with her because he was denied a room at that location, and he became aggressive, and at that he slapped Miss Sydney Fields across her face with an open hand. There was surveillance footage of this incident recorded by the hotel, and it does depict the slap to the victim, Miss Sydney Fields, in light of the fact that this defendant has at least 3 prior convictions for violent offenses, to include assault and simple battery in both Tennessee and Georgia. And the fact that he violently attacked a stranger who was just doing her job working at the hotel. The state does have concerns about safety of the community, as well as this defendant's likelihood to reoffend. So the state's recommendation for bond is a $7,500 surety bond. No further contact with Miss Sydney Fields. Stay away from the La Quinta Inn at 6260 Peachtree Dunwoody Road in Sandy Springs, and an anger awareness class. Nothing further.
Okay.
Yes, Your Honor. My client, he is from Chattanooga. He is a certified electrician. He's worked with the same local Tony's electrician up in Chattanooga for the last 5 years. He does have 2 kids that he does support. He's the sole means of support. I think there's, and again, this is always for trial, but I don't think it's a slap is what we think of in a domestic violence situation. I think it's more of a tap, trying to get, but not what we think of as a, like I said, a slap as in a DV case. So we would ask the court to give us a $1,000 good bond.
All right, based on the history that I've heard, and I think he stated he was from Chattanooga, I'm gonna order that $7,500 surety bond. I'm going to order a stay away from 6260 Peachtree Dunwoody Road, Sandy Springs, which is the La Quinta Inn. Stay away from that location. No further contact with the victim, Sydney Fields. No drugs, alcohol, or weapons while on bond. And that 1-day anger awareness course, I will order it. And I think that's it. Anything else, counsel?
No, Your Honor, thank you.
Thank you.
I'm sorry, Your Honor, once again, what was that bond amount?
$7,500 surety bond.
Thank you.
Mm-hmm.
And next we have Mr. Albert Lee, position 14.
And after that, ACDC needs to hear their rights. I have 2 ladies over here.
Okay.
Thank you.
This is case number 23 CR 001274G, Albert Lee. In charge of 1 count of simple assault, family violence. The offense date is March the 3rd, 2023. Pre-trial.
Showing 4 cycles. The driving while license suspended or revoked conviction from 2011. and then one probation violation from 2021. And the underlying charge was a first offender for disorderly conduct and harassing phone calls. And nothing further.
All right,
Hey, y'all get out.
state.
Yeah, you take it up. Where you at?
It's your case, Deputy Falk.
No, actually, this is Albert Lee, correct?
Yes.
It's Miss Campbell's, but let me see, she may have just had to step away for a moment.
All right, there
thank
she
you.
goes. Okay.
I apologize. I did not hear the name. I'm so sorry.
Oh, that's okay. Position 14, Albert Lee III.
Yes. Sir. As to Mr. Lee, the incident date was March the 3rd of this year at approximately 2:50 in the morning at the location of 3020 Hampshire Walk Southwest. The victim, Miss Nikisa, and that's spelled Nekiesa Parker, advised the officers once they arrived at that location that the defendant was being aggressive towards her when she pulled up into his driveway to drop off some custody papers that the defendant needed to sign in order to sign over custody to her for their 2 children they shared together. The victim advised that she had their newborn baby in the front seat with her. And at that time, the defendant repeatedly began punching the driver's side window while she was seated inside of the vehicle with the kids. And according to the victim, the defendant punched the window until his hand started to bleed. And according to her, she gave 2 different statements, but her first statement was that the defendant pulled a handgun out on her and threatened to shoot her. She later came back and changed her statement to the officers and said that the defendant didn't actually pull out a gun, but that he did act as if he would do so. In light of this defendant's history for just similar type of behavior with that Clayton County first offender treatment for felony terroristic threats, as well as harassing phone calls, and then another 2015 conviction for harassing phone calls, the state does believe he's a likelihood to reoffend and a danger to this victim. So the state's bond recommendation is a $10,000 surety bond, no alcohol, drugs, or weapons while on bond, no further contact with Nikisa Parker, and a stay away from the incident location. Nothing further.
All right.
Yes, Your Honor, this is a incident that was totally escalated by the victim in this case. She comes over to his place, okay? He did not go to her. And then instead of having custody papers served, she's dangling them in front of his face as to get in this, an excitement out of him. He did not touch her, did not hit her. You notice how she changed her story? Again, oh, he has a gun. He doesn't have a gun. That's a huge difference. It goes to the credibility of this victim and the fact that she is the one that's over there instigating this incident to get this exact situation that we have right now. So we would ask the court, my client, that is his place. She does not live there. She's not on a lease. They're not together. He is a production supervisor for Pepsi. They have 2 kids, and he is the one who actually called 911. This is totally contrived by the victim in this case, and we'd ask the court to look at that and give him a $3,000 signature bond.
All right, and so the
Your Honor.
parties were, go ahead.
Oh, just briefly, I would note that she never changed her statement about him having a gun. She just, both times she said there was a gun, but the dispute is whether he actually pulled it on her or not. But she maintained that there was a gun involved, nothing further.
And just one quick thing, that is not what he's charged with. If that was a gun involved, it would be a felony. We would not be here right now. This goes to the credibility, again, of this victim and of this case.
It wouldn't necessarily be a felony if he didn't point it at her, so.
All right. Um, and I believe I heard correctly, the parties were in a relationship. No?
They share 2 children. And at least we know that the infant was in the car when this happened.
And one last thing, PD Melnick, what did you tell me about Mr. Lee's work history?
He is, he works at Pepsi. He's a production supervisor. He's been there for many years. He's stable.
All right. I am going to order that $10,000 signature bond through the jail. I'm going to order no further contact with Nakia Parker. If there's any visitation allowed through the children, it will be by a third party facilitating any visitation. No drugs, alcohol, or weapons while on bond unless prescribed to him. And I'm going to order, because he should have the means to do this, a one-day anger awareness course. Anything else, counsel?
Your Honor, the state would just request that if you're going to do the signature bond, that it be through pretrial services so that this defendant can be monitored. Not only was he violent with this victim, but he has 2 prior convictions within the past 6 to 7 years for at least threatening violence or threatening to kill somebody or terroristic threats, felony. And the state is also asking that he be commanded or instructed to surrender all of his weapons while he's on bond. Nothing further.
All right, I certainly agree that Mr. Lee, if you have any other weapons, you need to surrender them. Your attorney will tell you how to do that so that you have no weapons around you while on bond. As far as this being monitored through pretrial at the jail, I'm assuming Ms. Melnick has a good address and location, and he seems to have stable employment if he's been at Pepsi for some years.
Yes, Your Honor. The location's on the incident. Like I said, she's the one that came to him.
So I'm going to just leave it with the jail and not change it to pretrial services.
Thank you, Your Honor.
All right, thank you.
Your Honor, I'm sorry once again, but what was that bond amount?
That's okay. $10,000 signature bond through the jail.
Thank you.
Mm-hmm.
You can go to ACDC next.
Okay.
Milton.
If she's not ready, we can go to position number 6, Mr. Douglas Hush.
She's walking. She's gonna get you. She's coming.
My guy's ready.
You making her run. She's running. Yeah, she's gonna get you for that.
Okay, hi, Your Honor. Okay, I have 2 ladies here that needs to get their rights read. And
I understand.
And sitting before you is position 1, Blake Johnson.
Okay.
Oh, Lord.
This is case number 23 CR 001261J. This is Brianna Blake Johnson, charged with 1 count of battery family violence. March the 3rd, 2023 is the offense date. Pre-trial.
First arrest.
Okay. State.
Yes, Your Honor, that's correct. The facts are that on the incident date of March 3rd of this year at approximately 11:30 at night, the location of 2861 L Point View Drive in East Point. Officers were dispatched for a fight call. Upon arrival, they met with the victim, whose name is Jarrett Wilson, and that's spelled Jarrett. Jarrett and the defendant, Miss Brianna Blake Johnson, are live-in girlfriend and boyfriend. The defendant actually admitted to the officers that they had been in an altercation and that she picked up pieces of broken glass and she threw it at the victim, Jarrett Wilson. When the officers arrived, they did observe a gash to Jarrett Wilson's right cheek, consistent with having glass thrown at him. And in light of the fact that there has not been a sufficient enough cooling off period, the state's bond recommendation is going to be a $3,000 surety bond, no further contact with Jarrett Wilson, stay away from the incident location of 2861 L Point View Drive in East Point, and 1 day anger awareness, nothing further.
All right.
Yes, Your Honor.
PD Melnick, I do see the victim on the line. Do you want to go before or after the victim?
After the victim, Your Honor.
Okay. All right, Mr. Wilson. Can you hear me? Unmute yourself.
Yes.
Good afternoon. Do you wish to address the court today?
Yes.
All right, raise your right hand first for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Absolutely.
All right, put your hand down for me. Are you in fear of Miss Brianna Blake Johnson?
No.
All right, and the two of you are residing together currently, is that correct?
Yeah.
Yes or no?
Well, she has her own address, so we come over for extended periods of time.
Okay. Do you all have any children together?
No.
Okay. And you still want contact with her?
Yeah.
Okay. All right. ASG Campbell, any cross-examination?
No, Your Honor.
All right. PD Melnick?
Yes, Your Honor. Let me fill in the gaps a little bit. If you saw, I think he saw his reluctances. Ms. Garner, this is her first ever. And I do want to highlight that and keep that in the forefront of everyone's mind. But she was displaced. The affidavit for arrest says that she was there for about 3 weeks. She's displaced from the big ice freeze storm that we had, where you had several apartment complexes and everything around the city, buildings and everything froze and pipes froze, and it displaced her. So that's why she's sort of temporarily there. I did speak to her in advance, and that she does have a god sister that she can go and stay with. And we are asking for $1,000 signature bond on this case. You heard from the victim. He is not scared of her. This is a one-time incident.
All right. I'm going to order a $3,000 signature bond. I'm going to order that signature bond be through pretrial per judge. Want to have some monitoring. No drugs, alcohol, or weapons while on bond, unless anything prescribed to her. I'm going to ask for a stay away from 2861 L Point View Drive in East Point, so that there is an ample cooling down period. I'm going to order right now no further contact with Jarrett Wilson. Stanvey has a laceration, and I'm listening to some of the allegations that do concern me, although this may be her first offense. And that's all I'll order at all that I'll order at this time. Anything else, counsel? I don't think you should. Your attorney's going to tell you not to.
No, we're not doing anything.
My belongings.
Oh,
Some of my belongings are still in his possession,
And so
Okay.
I would like to know how I would go about retrieving that.
All right, very good point. We'll give you a pass on that. Because all right, I am going to order a one-time law enforcement escort for you to go back to get your personal belongings from there. Please do not go back by yourself, but as you are exiting and released, make arrangements with law enforcement to meet you there so that they can help with the handoff and escort you to that property to get your personal belongings, okay?
Okay.
All right. Anything else, counsel?
No, Your Honor.
No, Your
All
Honor.
right. That will conclude your case.
Thank you.
Next is position 23, Ms.
Okay.
Toxco.
This is case number 23 CR. I'm sorry, 23 CR 0012698. Terry Tosco, and I apologize if I'm mispronouncing your name as well. It is not intentional. You're charged with 1 count of disorderly conduct and a 2nd count of simple battery against a police officer, police dog, corrections, or detention officer. And that offense date is March the 5th, 2023. Pre-trial?
I'm showing 6 cycles, 1 out of Virginia, 5 out of Georgia, a 2009 conviction for DUI, and then a 2009 conviction for theft of services. And nothing further.
All right.
Yes, Your Honor.
ASG Duncan, hold for 1 second. I need to do one quick thing. Give me 2 seconds. I'll be right back, okay?
Okay.
Hello, Cisco Unity Messaging System. From a touch-tone telephone, you may dial an extension at any time. For a directory of extensions, press 4. Otherwise, please hold for an operator. Hello, Cisco Unity Messaging System. From a touch-tone telephone, you may dial an extension at any time. For a directory of extensions, press 4. Otherwise, please hold for an operator. Hello, Cisco Unity Messaging System. From a touch-tone telephone, you may dial an extension at any time. For a directory of extensions, press 4. Otherwise, please hold for an operator. Hello, Cisco Unity Messaging System. From a touch-tone telephone, you may dial an extension at any time. For a directory of extensions, press 4. Otherwise, please hold for an operator. Hello, Cisco Unity.
I really don't know what this here is
From a
all
touch-tone
about.
telephone, you may dial an extension.
I heard someone's voicemail. I don't
Yeah, I
think
have
it-
no idea what that was about.
I apologize. I was calling
Oh,
South. to give numbers.
It was you, Miss Kim.
Thank you for admitting that, Ms. Kim. We will
Sorry.
forgive you. That's okay. All right. I'm sorry. ASGLS Duncan, please proceed.
Yes, Your Honor, this incident did occur yesterday at 890 Atlanta Street at the Gaslight. I believe that is a nightclub or lounge. This defendant did enter the location and was seemingly and very intoxicated. She was told to leave that place by the on-duty security guard, who was an off-duty officer working an approved secondary job at that location, Officer D. Miller. When asked to leave, the defendant did not want to leave. This defendant became belligerent and started shouting obscenities and acting very aggressively. Officer Miller further instructed this defendant to leave the location, and she began pushing Officer Miller in the chest with an open hand and pointing in his face with her fingers and making contact with his face. The state does have concern about the risk of reoffense. In this case, this defendant does have a 2009 DUI conviction, as well as a DUI arrest in 2007 and a DUI arrest in 2008. Even though those cases were not convictions, they do add to a pattern of law-breaking behavior when intoxicated. So the state does have concern in that regard, Your Honor. For those reasons, the state is going to be requesting a $3,000 total surety, $500 on the disorderly conduct, and $2,500 on the simple battery against a police officer. No further contact with Officer D. Miller. Stay away from the Gaslight located at the location indicated on the record. 1-day anger awareness, no alcohol, drugs, and weapons, no further violations of Georgia law, and an ADET.
All right, PD Kim.
Yes, Your Honor, Miss Terry Tuxco is 55 years old, and she has 2 children who are adults. Your Honor, she has not had an employment for a while because of different situations. She graduated from high school in Virginia, and she came to Georgia about 17 years, and she has a self-employment business, Airbnb, at her own house. So she makes a little bit of income just to get by. So, but she does not have a lot of money to pay for the bond. And yet, we would like to request for a signature bond so that way she can go home. This happened just, because of alcohol, and even though she had few DUI incident, that's very, very remote. It was from 2009. So I don't think ADET is appropriate at this point. We would like to request for a signature on bond. If Your Honor is not inclined to give her a signature on bond, maximum $1,000 good bond. Thank you.
Okay. I'm going to order a $3,000 surety bond. I'm going to order stay away from 890 is it Atlanta Street, the Gaslight Lounge. I'm going to order no further contact with Officer D. Miller. I'm going to order no drugs, no alcohol, no weapons while on bond. And I won't order an ADT at this point. I'll hold on that. And that should conclude the case.
Will you break down that?
Oh, I'm sorry. Yes. 500 on the disorderly conduct and 2,500 on the simple battery.
Your Honor, she has no control over whether she can have a contact with the officer or not. If an officer has a duty to serve when she has to call the police, can we just change that to no further violent contact?
Yes. I'll make that no further violent contact.
Thank you, Your Honor.
Yes. All right, that'll conclude this case.
Thank you, Your Honor.
Thank you.
Your Honor, next we have position number 6, Mr. Douglas Hush. Position number 6.
Okay. This is case number 23 CR 001268D. And I'm looking at the calendar, so the name is Douglas. Hush is the last name.
Yes.
Okay, I think they may have it written backwards, looked like, I wasn't for sure if Douglas was the last name. All right, you have charge of 1 count of cruelty to children in 3rd degree, 2nd count of battery family violence. The offense date is March the 5th, 2023, pretrial.
I'm showing 1 prior arrest from 2015 for possession of marijuana less than an ounce. That case is dismissed. No.
All right. All right, ASG Campbell.
Yes, Your Honor. The facts are that on the incident date of March 5th of this year at approximately 4 in the afternoon at the location of 820 West Marietta Street Northwest, officers were actually dispatched for a call for domestic dispute. The person who made the 911 call was a 6-year-old minor child with the initials XYZ. That child is the child of both, or it looks like that child is the child of the victim in this matter, Miss Aaliyah Wizard or Wizard. Her last name is spelled WYZARD. Miss Wizard's 6-year-old child reported that his mother, Miss Aaliyah Wizard, was in a fight in the apartment with her current boyfriend. After the caller made that report to the police, he hung up the phone. Upon arrival, the officers actually met with the defendant initially, who stated that there was an altercation between himself and the victim, Miss Aaliyah Weiser, but that it was not a physical altercation. At that time, the officers asked the victim, Ms. Weiser, to step outside and speak with them, and she provided a completely different statement. She advised the officers that the altercation did turn physical and that the defendant hit her several times and that he also threw a coat rack at her. And when the officers arrived, they did observe the broken pieces of the coat rack there within the apartment. They also observed several scratches on Miss Weiser's person, on her chin, her arms, and her fingers. Additionally, Your Honor, the victim did tell the officers that there has been a history of physical abuse in the relationship with the defendant and that she feels stuck. It is my understanding that the parties, they do live together and they do share 2 minor children. And Your Honor, in light of the serious allegations that are before the court today, where at least one minor child who's 6 years old made a phone call to the police because his mother was getting battered while he was present, the state does have serious concerns about the victim's safety as well as the children's safety. So the state's recommendation for bond is going to be a $6,000 total surety bond, $5,000 on the family violence battery, and $1,000 on the cruelty to children in the 3rd degree. The state is also recommending no further contact with Miss Aaliyah Wizard or her minor child with the initials XYZ or XYW. I'm sorry, that should not have been Z, XYW. A stay away from 820 West Marietta Street Northwest, as well as anger awareness, nothing further.
All right, PD Melnick.
Yes, Your Honor. This is his residence, that she does live with him, but I did discuss with him in advance that he may have to vacate the premises, and he said he can go to his parents' house in Snellville. He works 2 full-time jobs, Your Honor. He works for Saks Fifth Avenue, and he works for citywide parking to support the kids in the family. He has no prior convictions whatsoever. So we'd ask you again, highlight that, and so we're asking for a $3,000 signature bond on the battery and a $1,000 signature bond on the cruelty to children. I guess I think this is consistent with him agreeing to leave the premises and agreeing with his no criminal history.
And Your Honor, I apologize. I should have asked you to sound for the victim when appropriate.
Oh, okay. Is the victim, Ms. Weisert, on the Zoom call? Ms. Weisert? I don't believe she is. All right, I'm going to order a $6,000 signature bond through pretrial per judge. I'm going to order a stay away from 820 West Marietta Street Northwest. I'm going to order that there be no further contact with the victim, Aaliyah Weisert, or the 6-year-old son, XYW. Gonna order no drugs, alcohol, or weapons while on bond. I will allow a one-time law enforcement escort to return to the property to retrieve any personal items that the defendant may need. And if there's any visitation allowed with the children, that be precipitated by a third party for visitation. So there
Will you
are
break
no.
that bond down, Judge?
Yes, that is 1,000 on the cruelty and 5,000 on the battery. Anything else, counsel?
Not for the defense.
No, Your Honor, thank you.
All right, thank you. Oh, I think your client has a question. Is something about the bond conditions?
No, it's not about the bond conditions, it's about the living conditions. Since I'm the lease holder of the apartment, if I'm not able to return that, she's not legally a resident.
You're out, I'm gonna ask you to stop talking right now. We talked about this in advance and you're gonna go stay with your parents. Thank you.
But
No, no buts. We're done. Thank you.
Yeah, be careful. All right, thank you. Next matter. Did you get that, deputy?
Next, we have position number 8, Mr. Jiwa.
This is case number 23 CR 001258F. Mr. GY, you're charged with 1 count of simple assault, family violence. The offense date is March the 4th, 2023. Pre-trial.
2 cycles, no convictions, 1 FTA in 2018.
All right, state.
Your Honor, the facts are that officers responded to 806 Hampton Drive in Sandy Springs and met with Ms. Stevenson. She advised the officers that during a verbal altercation, the defendant grabbed a knife and began stabbing paintings belonging to Ms. Stevenson while in her presence, and the escalation in the defendant's actions placed her in the fear of receiving a violent injury. Although the defendant does not have any criminal history, the state does have concerns that since they live together and share children, it's likely that the defendant couldn't attempt to influence the victim and convince her not to prosecute. The state's recommendation is a $3,500 surety bond, no further contact with the victim, stay away from the address, third-party contact for the child, 1-day anger awareness, and no drugs, alcohols, or weapons while on bond. That's all from the state.
All right. McLeod.
Yes, Your Honor, my client is 36 years old. He is gainfully employed, he tells me, with Mercedes-Benz. I noticed that the prosecutor failed to point out that the alleged victim was arrested and was currently in on our hearing in felony. I had to actually leave this because the judge over there asked me to come to speak on this issue as to what my client wanted with respect to their contact. I just want to put that on the record. My client is the father of two very young children, a 2-year-old and a 3-month-old that he shares with the alleged victim. They actually do not need to occupy the same space. My client has his own place, and he actually pays for her to be accommodated in the space that this incident allegedly happened. He does have a room in that house, Your Honor, that he works because he works from home. And because they have 2 small children, he regularly goes over there to help with the children. So he has a space. He says that the paintings, he did not stab any paintings in front of her. That's just an exaggeration. He was trying to leave and she was preventing him from leaving. He was in his room and these were his paintings in his room in the property that he actually pays for her. There's no suggestion that he touched her or anything. And I just want to point that out. My client does not have to be in that space. He does have his own place. He, of course, wants to have contact with his children. He would prefer no further violent contact, which is what I was asked when I went over into felony, what my client's preferences were, and his preferences, no further violent contact with this person. But I want to put it on the record that to suggest that he was, did anything to harm her. He had been working for 12 hours straight, he told me, and she just kept coming to talk to him when he was working, and he asked her to just put that aside. She had gone out, she came in at 3 a.m., he was there with the children, she wanted to start arguing again, and he just didn't want to have anything to do with that. He just wanted to take care of his children. He has no record on, he's 36 years old. I would ask the court to give him a signature bond so he can get out and take care of his young children, because that is his biggest concern. And he does not have to live with her. He has his own place.
Yeah, if I may, real quick. The victim is incarcerated. I forgot to mention that. I looked over my notes. I just missed that additional note that I made. But she is incarcerated on an unrelated charge of false imprisonment. It is not related to this defendant, as far as I'm concerned.
Okay. Do we know where this child is?
There are 2 children, Your Honor.
2 children.
A 3-month-old and a 2-year-old.
Okay.
My client can speak to that.
Yes.
Yeah, with my brother.
With your brother? Okay.
Yes.
All right. I'm going to order the $3,500 signature bond. I'm going to order that through pretrial per judge. I'm going to order no drugs, alcohol, or weapons while on bond. And not for sure, as far as this location, since I heard that defendant does have somewhere else to go live.
He does, Your Honor. He pays for that accommodation for her and the children, but he actually has somewhere else he can go where he lives.
Let's do that because we don't know if the victim will be coming back to that location or if she'll get bond in her case or not.
He doesn't put her on the street, Your Honor, because of the children too.
Okay, so let's do this. Let's let Mr. Jiwa, and I apologize if I'm mispronouncing your name, to stay away from 806 Hampton Drive in Sandy Springs. And no further contact with the victim, Ms. Stevenson.
Your Honor, may I speak to the whole issue of the no further? They have 2 very young children, and he is the primary caretaker, he tells me, for these children.
Right. And I know that he can't be around her. I'm concerned about the allegations, even though there's an allegation of a knife. It just happened to go inside the paintings, and I understand it may not have touched her, but I am concerned about that and the fact that there's two small children around when that's happening. Didn't say he couldn't be around his children in case he gets custody of them and he's out before her. But I just want to make sure that if she gets out today or tomorrow or something close by in time, that there's been some cooling off there. So I do realize that he may end up with custody of both of the children. And if there's going to be visitation, that it be facilitated by a third party, but I'm anticipating that he would end up having custody. Since it sounds like he may get out before her. And I do feel, and I'm sensing that from Ms. McLeod, that we want to do possibly no further violent contact, but I have some reservations on that.
I understand, Your Honor. My biggest issue is the children, and that is my client's biggest concern, Your Honor, the children.
Well, I'm not going to order that you stay away from them at all. There is no cruelty charge here. So you're able to get custody of them, that is fine. But if you're going to do any visitation or exchange with yourself and Ms. Stevenson for right now, that needs to be facilitated by a third party so that the two of you will not have any immediate contact, okay? Okay.
And I just want to say on the issue of the fact that the judge on her felony hearing asked for me and contact suggests that it is related, Your Honor, to him.
Yeah, that's what I was about to clarify. I misspoke. The victim is this defendant. I was just made aware, and this incident happened on a different date. So it wasn't the same date, but it is the same defendant.
Okay, so it is between, okay, the parties. All right, well, I'm gonna stick to my ruling, and if there needs to be some modifications based on what progresses down the road, then your attorney will know how to bring it back before the court or any modifications based on what may happen as far as custody or things of that nature, okay?
Yes, ma'am.
All right, good luck to you. Did I say no drugs, alcohol, or weapons while I'm by?
You didn't do
Automatic.
It's gonna be automatic, but yes, okay. All right, thank you, nothing further.
Next, we have position number 10, Mr. Rodriguez Gore, I'm sorry.
All right, this is 23 CR 001264J. Rodriguez Gore, charged with 1 count of battery family violence, a 2nd count cruelty to the children in the 3rd degree, and a 3rd count of simple battery family violence. Offense date March the 5th, 2023. Pre-trial.
I'm showing 6 cycles, 2012 conviction for willful obstruction of law enforcement officer and criminal trespass, 2011 conviction for possession of marijuana less than an ounce, and then an open case 22 CR 006-723J, and that's for battery family violence. And nothing further.
All right, state.
Your Honor, the facts are that on March 5th of 2023, officers responded to 1475 Sand Bay Drive Southwest in South Fulton, Georgia, in reference to a domestic dispute. They made contact with Miss Saxton. Miss Saxton told the officer that she and the defendant had got into a verbal altercation over her not cleaning the house. Miss Saxton, Mr. Gore put paper towel in her face, and that's when the altercation became physical. Miss Saxton struck him in defense of his actions. She told officers that Mr. Gore hit her with a bag of diapers, causing a laceration and a bump. Also, her minor son was threatening to call the police when Mr. Gore slapped him as he was attempting to call the police. We have had some contact with Ms. Gore. She stated that the defendant had some alcohol issues, and she was also charged and released, and she still wants contact with the defendant. However, the state has some concerns as on 10/22 of last year, Your Honor issued a $5,000 pretrial release bond where you ordered the defendant to stay away from that address and away from that victim. However, within a few months, he's back there. They're fighting in front of the kids. He's slapping children. So the state would recommend a $5,000 cash bond. No further contact with the victim or the minor child. Stay away from that address. 1 day anger awareness, as he was previously ordered. I'm unsure if he completed that or not. No alcohol, drugs, or weapons. And we do believe that he has a risk of reoffending, and he will possibly intimidate the witness.
What's the breakdown on the?
It would be $3,000 cash on the battery family violence, $1,000 on the cruelty to children, and third, and $1,000 cash simple assault family violence against the minor child.
All right. Ms. McLeod?
Yes, Your Honor. My client is 32 years old. He is gainfully employed as a driver, Your Honor. He is also the father of 4 minor children. He has primary custody of his 10-year-old and 14-year-old daughters, and he also shares 2 children with the alleged victim. He denies that he was the aggressor in any of this, Your Honor. I believe even the warrant supports that she was the one who attacked him. He does need to be around these children because, as I said, he is the primary caretaker for these children, Your Honor. And I do understand that there is an outstanding case, but there has been no disposition yet, and my client is definitely presumed innocent in this case. I would like to point out that prior to this alleged incident in October, my client had no history whatsoever of any kind of violence. A cash bond is not going to be something that he can afford, Your Honor. So I would ask that the court set him a reasonable surety bond so he can get out of jail and get back to his children.
Okay.
With respect to contact with the alleged victim, Your Honor, my client does not mind having no further violent contact. That would be his preference.
Your Honor, if I may, the defendant was ordered in case number 22 CR 006-723J, no contact with the victim in this case. Instead, he violated the order, went back to the residence, and committed assault against the victim and slapped the minor child. So the state would prefer the no contact with the victim or the minor.
Your Honor, my client denies that he slapped the child. That's the first thing. The other thing is that this is his home where he lives with 2 children who are not the alleged victim's children. And the other 2 children that he has with her, it really is her place. He tells me that it's really his place. He's always lived there. He's lived there for quite some time. And she has somewhere else that she can go if she has to. But he lives there with his children, 4 children.
So I'm assuming the lease is in his name?
It is in his name, Your Honor.
Sand Bay Drive?
Yes, Your Honor.
Well, I am concerned about the previous order from October 2022.
Maybe, I was thinking maybe that was not explained at the time, Your Honor, that this is his home and that he has 4 children that he's taking care of at this location.
Right, well, that's what he has an attorney for, to talk to you to find out what he needs to do in order to not violate his bond. And I tell people often, don't go back there alone, don't go back, because you're just gonna get rearrested and you're gonna be back down here again.
I understand, Your Honor, but he wasn't my client at the time when he was initially arrested. Because I would have made sure that he understood that.
Right. Well, I just need him to understand at this point, because I don't like to hear of second incidences continuing to go on after, and it's a very short period, just a couple of months, and he's back here again. So I'm going to order the $5,000 cash bond, and that's $3,000 on the battery, $1,000 on the cruelty, $1,000 on the simple battery. I'm going to order stay away for 1475 Sand Bay Drive in South Fulton, I believe you said, ASG Young.
Yes, Judge.
And I'm going to order no further contact with Miss Saxton.
Can you give one time police escort, Your Honor, because he does have property in the house and he also has the children.
Right. And I will allow that one-time police escort for him to retrieve his personal items. And I'm assuming the two children that are not the children of the victim.
That is correct.
I guess we'll need to say that, Ms. Bridgewater. Guess we'll add that as well. I've not done that before, but I'll go ahead and be clear. Yes, Deputy Falk.
Your Honor, I will say that there was in the bond order a previous one-time law enforcement escort to retrieve belongings. And so we do have some concerns because this was ordered before.
And he went back and then, yeah.
The fact is, Your Honor, there are two children that he's responsible for and he can't just leave them there.
Well, I understand. I imagine Miss Saxton will probably do something about it. I don't know. She may be close to them and may allow them to stay. I'm thinking, and I see Mr. Gore, you have your hand up, so tread light and be very careful, is that I will order a police escort for him to go back just to retrieve the children, since they are not her children. I do, Deputy Falk, have some concerns about that. Or, I guess he could ask the police to go get them and bring them to him without him being there. So that nothing, happens that would put either party in violation of the terms. What do you all think about that? Like I say, I've never had to order that before.
I'm thinking, Your Honor, that he is the primary custodian because we discussed it at length of these two older children. They're two girls, 10-year-old and a 14-year-old. Also, the fact is, it's obvious he's been living in the house. Yes, there may have been a previous order, but it's obvious his clothing is there and other stuff are there in his house. So I do not think it is unreasonable under the circumstances for him to have a one-time police escort so he can go back there and get his belongings and his children. The two children that are not her children.
Any rebuttal, ASG Young or Deputy Falk?
Your Honor, I wanted to see if Nigel Saxton is on the Zoom. Maybe she could kind of shed some light as far as the children goes. There is some concerns, as Deputy Falk mentioned before. He was supposed to already have those things and stay away from the address. If he would have done so, we would not be here now. So that's all from the state. Ms. Saxton, if you are present, you can speak up.
Don't think I see her. Well, there's an iPhone. There's two iPhones with no names. All right. Miss Saxton is not here. As long as he takes a police escort, I guess if he has some other belongings, I'm going to be a little more specific in this one is Bridgewater and say he is not to go in the home. He is just to have the escort there. And hopefully Miss Saxton or somebody can bring him his belongings, but I don't want him to go inside the home.
Okay.
The children need to come out. The children need to come out with their bags and they're big enough to bring dad's clothes as well.
Yeah. Okay.
Or call me and we can talk. I don't want you to say anything here.
Your Honor, repeat that bond amount again.
That bond amount is $5,000 cash, $3,000 on the battery, 1,000 on the cruelty and 1,000 on the simple battery.
Okay. Got it.
Okay, thank you.
Thank you, Your Honor.
All right, nothing further.
Next, we have position number 11, Mr. Eddie Harrison Jr.
This is 23 CR 001271J. Eddie Harrison Jr. charged with 1 count of DUI, driving in the influence of alcohol, concentration of 0.08 grams or more within 3 hours or more, driving improper erratic lane change, driving window tint violation, and another DUI less safe, all with the offense date of March 5th, 2023. Pre-trial?
He has 3 cycles, 1 out of Ohio, 1 out of New Jersey, 1 out of Georgia. He has no convictions, felony or misdemeanor.
Okay. State?
Yes, Your Honor. He does have an extensive driver's history. No prior DUIs, but he does have a driver's history that goes back to 1989, indicating lots of infractions to include prior convictions for improper lane change. So as to the facts for this case, it happened yesterday at approximately 8:57 in the evening. I'm sorry. The location was Highway 9 and Norcross Street. And at that time, officers observed the defendant failing to make a proper lane change. And they did conduct a traffic stop. When they made contact with the defendant, he refused to roll down his car window as instructed. And eventually he complied. But when the officers immediately made contact with his person, they smelled a strong odor of alcohol emanating from his person. Additionally, they asked him to step out of the vehicle and he refused to do so. I'm sorry, he did step out of the vehicle, but he was verbally combative with the officer during the entire interaction. He refused to do the field sobriety test, and he was later transported to the Roswell jail due to his belligerence and the strong odor of alcohol. At that time, when he was at the jail, he did take a breath test and he did blow a .203. And he also had illegal tint on his front driver's side window, and the officer could not see inside the car. So the officer did measure the tint and it was 0%. Your Honor, in light of the fact that this defendant doesn't have any priors for DUI, but also in light of the fact that this incident was a danger to our community, the state's recommendation for bond is $3,000. Well, basically $3,000 in the DUI per se, a $2,000 signature bond on the DUI less safe, and a $250 surety bond on the 2 remaining counts of failure to make a proper lane change and the tint violation. And that'd be a total of a $5,500 split bond. And the state's recommendation is also no alcohol, drugs, or weapons while on bond. Nothing further.
Okay.
Your Honor, do you want me to start with the window tint violation? That serious?
Yeah, we'll start at the lightest and go.
But apparently that might be the most serious one. Okay, Your Honor. This was his first. He has no convictions. Report says that he was pulled over, possibly for the window tint violation. Anyway, there's a lot of talk about that. But anyway, he works for General Motors. He's a floor tech. He only brings in $1,500 a month. So we are asking for a signature bond. in the amount, a total of 6,000 on these cases, because basically any other type of bond besides the signature bond is going to be paramount to a no bond. So we are asking for $6,000 bond, again, highlighting the fact that he has no convictions. And this is his first, this is a one-time incident. It's not indicative of any type of pattern. So, and he had just bought, he told me he had just bought this car. So we would ask the court to consider that.
All right. I'm going to order a signature bond, and I'm gonna order that signature bond through the jail. But let me get the breakdowns correct. Help me with my math, Ms. Bridgewater. I'll make it a $5,000 signature bond through the jail. And is that 3,000 on the DUI? And then 250 on the erratic lane change and 250 on the window tint. So that's 500. So that's 3,500.
Yes, because you have 2 DUIs.
And then 1,500 on the other. Is that
Okay.
5?
That's fine.
Okay. No drugs, alcohol, or weapons while on bond.
And these are good bonds?
Signature bond through the jail.
Gotcha.
And I guess I would say no driving unless you have a proper driver's license from DDS. And that should do it. All right. That concludes your case, Mr. Harrison.
That's it, Your Honor?
Yes.
All right, you good. Next, we have position 12, Mr. Jackson.
Which Jackson?
James?
Okay. I have the other one.
No.
23 CR 00126 EE. James Jackson, you're charged with 1 count of battery family violence. Offense date is January the 6th, 2023. Pre-trial?
4 cycles, 3 out of California, 1 out of Georgia. A 98 conviction for theft out of California. And then a CWAC from 1991 out of California, and nothing further.
All right, state.
Your Honor, the date of the offense was January 6, 2023, I believe, according to the report. The facts are that the victim, Angela Cox, reported to the Zone 2 precinct and reported that Mr. Jackson had grabbed her by the throat and pushed her into a closet after she inquired about another woman that was present at the home at the time that she was dropping off her minor their child. She reported that he also grabbed her wrist as she attempted to leave, which resulted in some scratches to her person. The state recommends a $3,000 surety bond, no further contact with the victim, no drugs and alcohol or weapons, 1 day awareness, third-party contact with the child. We do believe there are some concerns with intimidation of a witness as they do share a child, and it isn't uncommon for defendants to attempt to persuade victims to drop the charges against them. No, nothing further.
And how much was the amount that you recommended?
$3,000, Your Honor.
Okay.
Sure.
All right, Ms. McLeod?
Yes, Your Honor. I would like for the court to sound for the alleged victim.
Miss Angela Cox, I see an angel. Or is it Angelina or Angel? Do we know who that is? It's Angel at the bottom.
Yes.
Is there anyone with the James Jackson case on the Zoom?
I'm sorry, I was trying to figure out how to unmute my microphone.
All right, what is your name, ma'am?
My name's Angel, last name Cox.
All right, and if you want to address the court, I'll have to see your face. You've got to turn on your camera.
I'm sorry. How do I? I accidentally hit later. I'm sorry. I didn't hit the button correctly. Please forgive me.
Okay. I don't know if you signed in to, when you were signing in, to select sign in with video, because if you didn't, sometimes
No.
that's the reason. I'm gonna have to move along. I have a little bit larger calendar today. There you go. Okay. State your name again for the record.
Angel Cox.
Okay. And do you wish to address the court today?
Yes.
Right, raise your right hand for me. I'm going to swear you in. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down. Are you in fear of Mr. Jackson?
No.
All right. You all living together?
We're not living together, but we're trying to find ways to co-parent.
Okay, how old is the child that you share?
He's 2 years old.
Okay. All right. I don't have any other questions for you to state. Do you have any cross-examination?
Briefly, Your Honor. Ms. Cox, were you the one who went to the precinct in Zone 2?
I did.
And you did report to officers that the defendant had grabbed you by your throat and had scratched you, right?
I said that the defendant grabbed me by my arm, but later as we were, I guess, arguing, he choked me.
Okay.
But he did not grab me by the throat and push me into the closet. He grabbed me by my arm.
And choked you, is that what you said?
Later during the argument.
All right. Nothing further, Your Honor.
All right, Mr. McLeod.
Ms. Cox, isn't it true that when you came to my client's home, you were drunk?
No, I was not drunk when I came to your client's home.
Isn't it true that he had to call the security to escort you away from his home?
He did call the security to escort me from his home, but he didn't have to. There was alcohol present there at his home, and he was already drinking even before I got there, along with the young lady. And I did have myself a glass.
Isn't it true that there was another woman at his house when you got there?
Yes, there was another woman when I got there.
It's true that that was why you got upset?
No, I got upset because, of course, we were in a relationship and he was lying to me. And I confronted him and I asked him a question and he did not answer it truthfully. And then I asked the young lady the truth and she just told me they were friends. So that was it. And there became an argument after that with me and Mr. Jackson.
Okay. Isn't it true that you did not call the police to the house at the time, did you?
No, I did not have the police to come at the time.
Okay, nothing further. Your Honor, my client is 52 years old. As pretrial has stated, he has nothing significant in his history. He is gainfully employed. He works as a music producer and a consultant in the music business. He does have 2 adult children and he shares this 2-year-old who he loves dearly with the alleged victim, and he wants to continue, of course, to be fully involved in his child's life. He denies that he was violent in any way with Ms. Cox. He does want to have further contact with her as long as it's no further violent contact, because he maintains that any violence came from her. And he tells me that they were actually at lunch recently with their child, because they are trying to co-parent this child and spend as much time together as parents with this child, when she announced to him that she actually had gone to get a warrant for his arrest. He was shocked when he heard that, but she actually told that to him when they were sitting in a restaurant eating together. I see a certain amount of manipulation here, Your Honor. My client totally denies that he was violent to her in any way. I would ask the court to give him a signature bond so he can get out of jail, continue to do his work, and to be fully involved in his child's life. Nothing further, Your Honor.
All right. Ms. Cox, you can mute yourself for me, please. The little red microphone. Thank you. All right. I am going to order a $3,000 surety bond. I'm going to, excuse me, order no further violent contact with Ms. Cox. I understand she's not afraid of him. This happened back in January. So I think
they do not live together, Your Honor.
And they don't live together. So I think we've had an ample cooling off period, in my opinion. And so I'm assuming, State, are you asking for the stay away or not?
We were asking from the stay away and a third party contact with the child, but as you mentioned, has been since January. So,
and also that is his home. This incident allegedly happened at his home, not at her home.
Not at her place.
That's correct.
So,
it was at his place.
yeah, and I understand, Miss Cox, you do live at a different location, correct? Yes.
I believe she lives in a different county.
You live in a different county, different location, correct?
That is correct.
Okay. All right. So I'm ordering no further violent contact, $3,000 surety bond. I'm going to order no drugs, alcohol, or weapons while on bond. And for right now, if there's visitation allowed with the child, I'm going to do that with a third party person to precipitate that or make sure that we're not going to have any other incidents between the parties. So find a good neutral person right now to help do the exchange or to arrange for visitation. And no drugs, alcohol, or weapons while on bond, Mr. Jackson. And I think that's it. Anything else, counsel?
Nothing further, Your Honor.
All right, good. Thank you.
Thank you, Judge.
Mm-hmm.
Your Honor, I have an announcement for position 13. These are medical reset.
Okay.
And we can go to position 16. Mr. Mwambo.
All right, this is 23 CR 001251A. Mr. Leonard Mwambo, and I apologize if I'm mispronouncing your name. You're charged with 1 count of theft by taking. The offense date is February the 28th, 2023. Pre-trial?
First arrest.
All right, State.
Your Honor, this incident did occur on February 28th, 2023 at Sunoco that's located at 52 Southwest Broad Street in Fairburn. The defendant in this case was working at that Sunoco when his drawers came up short about $700. And the defendant was seen on video after the store owner, Mr. Patel, looked at the video and saw that the defendant was improperly distributing cash between registers and exchanging his money inappropriately with money from the register. He had taken about a $20 bill from his pocket and got ones out of the register, and then could be seen placing other denominations of money between the $1 bills to make the stack seem as if it contained only $1 bills. However, the defendant took about $700 from those registers and tried to disguise it. Mr. Patel did view that footage, and he was able to positively identify the defendant from the surveillance. That surveillance footage was shown to officers, and at that time, officers did take out this warrant. The state understands this defendant does have limited criminal history. It's for these reasons that the state is going to be requesting a $3,000 total signature bond through pretrial services. No further contact with Mr. Patel. Stay away from that Sunoco. No alcohol, drugs, weapons, no further violations of Georgia law, and a theft class.
All right. PB Kim?
Yes, Your Honor. We do not have exact $3,000 signature on bond, but we would like to request for through jail. Mr. Leonard Wambo, actually, he is 32 years old. He's been here in Georgia from April 2021, and he has a 1-year-old daughter, and his wife is currently expecting another child. So he does need to work and take care of his wife and 2 children soon. Your Honor, my client denies the allegations, and we have not had a chance to review the video footage, how it looks, but my client has 2 different jobs, working really hard to make a living. We would like to request for $3,000 signature bond through jail. Thanks.
Okay. All right, I'll grant the $3,000 signature bond through the jail. Gonna order stay away from, is it 352 Southwest Broad Street in Fairburn?
It is 52 Southwest Broad Street.
Oh, just 52 Southwest Broad Street. Okay. And Fairburn, and I'm going to order a stay away from that location, which is the Sunoco gas station, understand?
Yes.
And also no further contact with Mr. Patel. No drugs, alcohol, or weapons while on bond. And that's all I'll order at this time.
Thank you.
Thank you, Judge.
No problem.
Position 17 and 18, Mr. McClure.
All right, I'm gonna call both of these. Position 17 is 23 CR 001270G. Ryan McClure, charge of 1 count of battery. And the offense date is December 24th, 2022. And position 18, Ryan McClure, case number 23 CR 001273G. 1 count of simple battery family violence. That offense date is February the 10th, 2023. I don't know if they're regarding the same victim or not. Are they, State?
They are, Your Honor.
Okay, same victim. Okay, go ahead and you can present on both, please.
Yes, Your Honor. Position.
Oh, I'm sorry. Hold on. Pretrial. Sorry.
He has 11 cycles, 5 out of Georgia, 6 out of Arkansas, 2 FTAs, a 2010 conviction for domestic battering, a 2010 conviction for violation of a protection order, a 2009 conviction for violation Act 266, and then a 2013 conviction for giving false name to law enforcement officer, and nothing further.
All right. Go ahead, Ms. Duncan.
In addition, Your Honor, this defendant did have an arrest for aggravated stalking and violation of a family violence protective order in 2015. However, that case was dismissed, and a 2014 simple battery arrest that was dismissed. This incident occurred November 24th, 2022 at 3300 Waswell Road, apartment 4212. The victim in this case is a Mr. Kenneth Plez, Kenneth Plez, Pelz. He indicated that he and the defendant are boyfriends, and he was visiting him at the time, and that they were having issues because the defendant was talking about taking some action that would be considered infidelity in their relationship. A verbal altercation ensued at that time, and he indicated that the defendant wanted him to leave, and so that when he was grabbing his belongings to leave, he was told that they can discuss it later. And then when he began to try to leave, the defendant in this case began throwing his belongings outside of the door, and he began pushing the victim in this case, and then assaulting him by striking him in the face with closed fists. Officers did observe on scene that the victim in this case, Mr. Plez, had a major knot and several abrasions to the left side of his face around the eye area, which included a swollen, bruised area from the pictures that I saw. Ambulance was requested. However, they took so long that the victim transported himself to the hospital. And in fact, this instance occurred. He did call the police. However, they didn't show up. So he did make this report. He was told to report it at the precinct. He did make this report at the Zone 2 precinct located at 3120 Maple Drive. We have a concern in this case about the risk of reoffense and the particular danger to this particular victim, given that this defendant does have a conviction for domestic battery in 2010 and a conviction for violation of protective order. It seems to us as if this defendant does take some issue with responding positively to court orders and shows a history of domestic abuse. It's for those reasons, Your Honor, the state is going to be requesting a $5,000 surety in this case. No further contact with the victim whose name is stated on the record in this case. A stay away from 3300 Roswell Road, apartment 4212, with one-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. This instance is charged as a battery because at this time it was clear that the parties did not live together. However, moving on to the second instance of violence between these parties, which is position 18, that did occur on February 10th, 2023 at the same location, it is indicated that officers responded to that location, and the same victim, Mr. Plez, indicated that his boyfriend and him were arguing about some funds in an account that they share together, and he was drinking, meaning the defendant, and they began arguing about access to that account. And at that time, the defendant put his hands on the victim, Mr. Plez, and pushed him and grabbed him and started to manhandle him to the point where he tore Mr. Plez's shirt. Mr. Plez then ran out of the door, which can be seen on surveillance video from the apartment, where the defendant is running after Mr. Plez. And a short time later, he can be seen on video getting in Mr. Plez's face and pushing him against the wall towards the apartment. At that time, Your Honor, the victim did not sustain any visible injuries. However, given that this is the second instance of violence between these parties, we do still have that concern about the risk of reoffense, given its history and the particular history with this victim. We do have that concern again about the likelihood to respond to legal processes. And then we also are we see that he is currently wanted for two things out of Arkansas. So we do have some concern about flight risks for those reasons, Your Honor, given this continued pattern of violence, this defendant's history with domestic battery and violating protective orders. We're going to also be requesting that $5,000 surety, no further contacts, stay away, 2 weeks of anger management, no alcohol, drugs, and weapons. For this second instance that did occur on February 10th, 2020, February 10th, 2023, it's indicated that the parties were living together at this time. Nothing further from the state.
Your Honor, my client is 34 years old. He denies that the allegations made by the prosecution are accurate. First and foremost, the parties do not live together, Your Honor. My client has made that clear to me that the gentleman in question does not live with him. And based on the warrant that I saw, it indicates that they do not live together. And the prosecutor herself said that the alleged victim said that they did not live together. This is my client's home. His name is the only one on the lease, and we do not want any kind of issues with him being able to return to his own home. As a matter of fact, the alleged victim left in February, on the 10th of February, when this incident, he was just there visiting and he left at that time. So this is my client's home. Just want to make that clear. My client is employed as a chef, Your Honor. He also tells me that he is currently in school. He tells me he wants to be a doctor, and that is where his studies are heading for. He is presumed innocent in this case, Your Honor. I would ask the court to consider, given that my client, any history that he has is remote, I understand that he does have a hold, but a $5,000 good bond is high, Your Honor. So I would ask the court to give him a bond of, say, $1,000 on each of the charges. Nothing further, Your Honor.
Again, Your Honor, the state would like to sound for the victim just in case he is here. And I do want to clarify for the record that both warrants indicate that the parties live together. But per my research on the first instance back in December, it was clear that they were not living together. However, there is no such distinction for the subsequent offense that occurred in February. That is the reason for the state's designation as battery and simple battery family violence. And given the history between these parties and the defendant's history, we think our recommendation is reasonable. Nothing further.
Okay.
If you have a question, you can always call me afterwards.
All right, on the first case, with the one count of battery from December 24th,
I'm sorry,
2000.
Your Honor. I didn't mean to interrupt. Could we sound for the victim just in case he is here? I'm not sure if he.
Oh, yeah. Mr. Kenneth Plez. Kenneth Plez. Yeah, I still have those 2 iPhones.
All right, that's all I wanted to be sure.
Mhm. All right, thank you for that. On the first case, I'm going to order the $3,000 surety bond. I'm going to order stay away from 3300 Roswell Road, number 4212. I'm going to order no further contact with the victim, Kenneth Plez. And I'm sorry, let me back up a minute. So that is the address for the defendant, right, and not the victim, did I?
That is correct, Your Honor.
Well, yes, Your Honor, for the first incident that occurred at the same location back in December, it was indicated that they weren't living together. However, both warrants state that they live together.
Who is that speaking this iPhone?
Kenneth Plez.
Oh, you're Mr. Plez. You're gonna need to let me see your camera, and I'm almost gonna ask, but I beg not to relay, is for you to put your name on. That's why we ask when everybody comes on the Zoom call that you put some type of indication of your name and figure out how to do that. So I can't talk to you until I can see you.
And Your Honor, while he's doing that, in the alternative, we'd ask for a one-time escort to verify.
Mr. Plez?
Hold on just a second, please.
Okay.
I'm sorry, I'm closed. I'm closed. Yes, I'm sorry.
Well, I'm gonna have to move on. If you can't get your camera on, I can't speak to you. And I don't want to go too far beyond.
Looks like he may be at work, Your Honor. His camera is working. I think he might be at work.
Yes, I apologize. I tried the best that I could to be in attendance. But yes, I am at work.
Okay. If you wish to address the court, I would have to see your face. I see
Okay.
your hand.
All right, hold on just a second. Yes, hello?
Yes.
Yes, I wanted to address the court. Uh, at the time of their arrest.
Your Honor, we can't see him.
Yeah, I still can't see you.
Okay, can you
I
see
see
now?
your feet. Well, no, there you are. Okay. You have a mask on. I can see you.
Okay, okay.
Okay.
Yeah.
Raise your right hand. Let me swear you in first.
Okay,
You
sorry.
affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury.
Yes.
Okay, put your hand down for me. Quickly, are you in fear of Mr. McClure?
No.
And you still want to have contact with Mr. McClure?
Yes.
Okay. Does anyone have any cross-examination for Mr. McClure?
I do just briefly, Mr. Pless. My name is Ms. Duncan. I work with the solicitor's office. I just want to ask you on the first incident that occurred on December 24th, 2022. Did Mr. McClure strike you on that day?
No. I'm sorry, on what day are you referring to?
The first incident between you all that did occur on December 24th, 2022.
Yes, but I wanted to go ahead and state that this was a misunderstanding, and I actually talked to the officer, and I wanted to drop the charges. So I'm not sure why he pursued this in the first place.
I understand that. I just have one more question for you. On the, you called the police on one occasion, you went into the police precinct to report this, correct?
Yeah, and also in that precinct, I also said I didn't want to press charges also, and I did that on body cam as well.
Okay, and in the second instance, you called the police because he struck you, correct?
Yes, that's correct.
Nothing further from the state.
Okay.
Nothing from the defense, Your Honor.
All right. On the, as I stated on the first case, is a $3,000 surety bond, stay away and no further contact. And no drugs, alcohol, or weapons while on bond. And then on the second case, ending in 1273G, I will make that one a $3,000 surety bond. No drugs, alcohol, or weapons while on bond. That one with the address, that would be a stay away as well, or is that his address?
Both the addresses are the same location, Your Honor.
Okay, so stay away and no further contact with the victim.
Your Honor, this is my client's address, and I believe nobody asked, the alleged victim is on.
Mr. Plus, do you live at that 3300 Roswell Road apartment?
Yes.
The state would renew its request, Your Honor.
For the stay away?
Yes.
Because you don't have a different address for the victim?
Right, he stated on the record that he does live there.
My understanding is that Mr. Pez has a home in Rex, Your Honor. He doesn't live with my client.
Does the victim, Mr. Plaz, live with you? Mr. McClure, now?
He can't be living with me because of the fact that what I'm trying to sit here and trying to say is that the Camden don't want him on the property, so I have to get out. I don't have the funds, and I have to pay the rent. And because if not, they're going to be putting him out. We've been dealing with each other off and on, but the thing is, he can't take care of what's in the house right now. I'm responsible. He's going, everything in there, he's going to lose.
I understand, but we want to make sure there's no more incidents between.
Yes, ma'am. I understand, but.
Can you imagine how many people come to court to tell me there won't be? And then I send them back and then they're right back here. So
I understand, Your Honor, but I'm in college for a doctor and work for a corporate company. I can't have anything on my record. I understand that this is a miscommunication through Mr. Plez. That's why my lawyer is asking for a signature bond. I'm begging you. I'm supposed to be in class today. I'm like seriously begging you, because if he's staying with me and they're going to go into the unit, the police officer already told me when I got arrested, he was at the house.
Which means there needs to be, this second case was just some weeks ago. There needs to be some separation, some cooling down.
No, Miss Your Honor, we're fine. I promise to God. I do not need anything for I'm supposed to be in class today. I'm begging you. My professor, I'm seriously begging you.
Where do you go to, what class?
Mercer University. I'm literally begging you for a signature bond. I'm trying to do better for myself. I just start making good money, Your Honor. I'm begging you. I'm begging. I'm trying to do something for my life.
Right.
And Mr. Pless has made it clear, and so has the defendant, given his recitation of what's going on, that Mr. Pless does live there, and it's the state's position to not displace the victim. So we would request a stay away, given the history of convictions for this defendant and his history with Mr. Pless. We think our recommendation of the $5,000 surety for both is more than reasonable. We would request for that stay away. He can take up other judicial avenues to do whatever he needs to, but at this time, we think it's appropriate for there to be a stay away.
Your Honor, what the state is suggesting as a bond amount is not reasonable under the circumstances. I would ask the court to consider giving my client a much more reasonable bond, because it sounds to me like the state is asking for a $10,000 surety bond. And based on the allegations, it's just not supported. And there's no reason to think that my client will not come back to court. He works here in Atlanta. He attends Mercer University. I think, he will come back to court.
And respectfully, Ms. McLeod, the judge has already ruled on bond, and she has ruled less than what the state has requested. So we ask that bond that the judge has set be requested. The state's interjection was to clear up the fact that the victim does in fact stay at the incident location, and we would like a stay away.
All right, Mr. Plaz, you still live at that location, is that correct?
Yes.
Okay. All right. On the first case, I had the $3,000 good bond, and no drugs, alcohol, or weapons. And I am going to have to do this because we are here to protect the victim, is to stay away from the 3300 Roswell Road, 4212. And I understand, I've heard your pleas, Mr. McClure, but we have two cases here. We have two cases close in time. And this is
the rent had to be paid for the unit, Your Honor. That's what I'm trying to sit here and say.
I understand. Well, he'll have to figure that out without you there. He will have to figure that out. And then on the second case, again, I will Order $3,000 surety bond on the second case with the same conditions to stay away and the no further contact with Mr. Ples. I won't order the anger awareness class at this point. But certainly I want to make sure that these things are not going to happen again. There will be no allegations or nothing else in the future, and no drugs, alcohol, or weapons while on bond. So both cases a $3,000 surety bond.
Thank you, Judge.
All right, thank you.
Thank you.
All right, thank you, Mr. Ples, for your time.
Position 20, Mr. Norris.
This is 23 CR 001252E. Randall Norris, you charge at 1 count of battery. Offense date is 3/4/2023. Pre-trial.
What was the last name?
I'm sorry.
What was the last name?
Oh, Norris. Randall Norris.
5 cycles, 3 out of Texas, 2 out of Georgia, 2 convictions, DUI 2013, unlawful carrying a weapon 2003. Nothing further.
All right. State.
Yes, Your Honor, this incident occurred on March 4th, 2023 at 878 Peachtree Street. The defendant and the victim were at a comedy show. The victim in this case is Jason Khalif. That's Jason, common spelling. Khalif, I believe CHALIFF. When the defendant is alleged to have been being rude throughout the entirety of the comedy performance to the comedian and others in the facility. After the comedy show, the defendant was with, the victim, my apologies, Mr. Khalif was with his wife, and he made a statement saying that if someone was working with him like that, they'd be fired. And I guess the defendant was angered by this statement, and apparently he jumped over a table and attacked Mr. Khalif, striking him with a closed fist in the face, causing his glasses to be knocked off, and for them to fall on the ground and cause bruising on the left side of his head and cuts on his shoulders and elbows. There is video footage of this incident, according to the warrant that was provided by the location's manager, Mr. Bob Place. The state does have a concern about the particular danger to this victim, as this is a random attack. Our victim advocate was able to make contact with the victim in this case, and I do believe that the victim is on the line if Your Honor would like to sound for him. However, when he spoke to our victim advocate, he did indicate that it was his first time at that comedy club and that the defendant was being rude. And that when he addressed the rudeness, the defendant attacked him, and he sustained multiple scrapes, bruises, and damage to his shoulder, as well as a possible concussion. He stated that he will be going to the hospital. He would like no further contact and some form of anger management and evaluations for the defendant. Given this defendant's history, and the particular incident, the state is going to be requesting a $3,000 total surety, no further contact with the victim in this case, a stay away from that comedy club at the address stated on the record, 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. And I do believe the victim is on the line when Your Honor feels it's appropriate to sound.
All right. Is Mr. Is it Jason Khalif?
I'm present.
All right. Do you wish to address the court today?
I'd be happy to.
All right, I'm gonna swear you in first. Raise your right hand. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
I do.
All right, put your hand down for me. All right, are you in fear of Mr. Norris?
Deep fear.
All right, and so you don't want to have any contact with him, I assume?
Absolutely not. He's an animal.
Okay. And so you didn't know him before this time, is that correct?
That is true. I've never seen this man before.
Okay. So this is just an attack, stranger to stranger.
It's a senseless act of violence. I think it might possibly be a hate crime because of my outwardly Jewish looks. But this man shows no remorse. no sympathy, possible skinhead based on his actions, based on the way my skin color, my looks, my facial features. It was a brutal attack. He punched me multiple times after he got me on the ground. And I think he's a danger to the community, to his family. And I'm scared. I think there's deep psychological impact. I'm going to speak with a psychiatrist about this. I no longer feel safe in public because of his senseless actions.
All right, thank you for taking time out of your schedule to do that. To come down to tell us that. Any cross-examination by ASG Duncan, by the state?
Nothing from the state.
Anything from cross-examination from PD Kim?
Do you go to that comedy club a lot?
Infrequently, I've been there several times.
Nothing further, Your Honor.
All right. Go ahead,
Yes.
PD Kim, and thank you. Hold on a second. And thank you, Mr. Norris. You can mute yourself for a second, and I want to hear from public defenders, and then I'll give my ruling, okay? All right, go ahead, PD Kim.
Yes, Mr. Norris is not an animal, Your Honor. I think that was very conclusive and prejudicial statement. He is 35 years old, and Your Honor, he's proud father of 3 minor children, 2, 9, 14. They both were involved. My client denies the allegation of being a first aggressor. He was also jumped on. And Your Honor, before we go any further, I would like to make sure that my client is a very good citizen. He has got a reliable job at Brent Scarborough as a mechanic. He worked for the same company for the last 6 years. He graduated from high school successfully, and he has done some college work, and there's no hate crime involved whatsoever. My client never ever even mentioned anything about what Mr. Jason was describing. I feel very sensitive because, however, that doesn't. I mean, it's kind of like a too much jumping from one to the other. So we would like to request for signature on bond because all these other charges are from 2012 and long time ago. So that's like very remote, and nothing was actually really related to any kind of violence before. So this is the first time incident that happened remotely. He's married. He's got to go back to his family to take care of his children. We want to ask for signature on bond.
Your Honor, I just want to clarify for the record that the victim is entitled to his opinion, and the warrant does indicate that there was video surveillance of this incident given to police by the establishment's owner. Nothing further from the state.
All right. I'm going to order the $3,000 surety bond. I'm going to order no further contact with the victim, Jason Khalid. I'm going to order a 1-day anger awareness course. I'm going to order no drugs, alcohol, or weapons while on bond. And I think that is it. Anything else, counsel?
The state was requesting to stay away from the incident location as he was jumping over tables to attack this victim at that comedy club.
And Mr. Norris was also a patron there as well?
Yes.
Okay. So Mr. Norris, I'm going to order you to stay away from the comedy club, and I did not write down the address, so.
The address is 878 Peachtree Street.
Okay. You just stay away from 878 Peachtree Street. And I think that's it. Anything else, counsel?
Nothing further from the state.
Nothing from defense either.
All right, that will be the ruling of the court.
Thank you.
21, Mr. Phillips. Jordan Phillips.
Okay. 23 CR 001254D, Jordan Phillips, charge of 1 count of battery, substantial physical harm. The offense date is March the 5th, 2023. Pre-trial.
One prior from 2020 that was for forgery. That case was dismissed.
All right, state.
Your Honor, this incident occurred at 3240 Verdant Drive, apartment 610. The victim in this case is Lauren Banks. That's Loren, last name Banks. It's indicated that she at the time was the girlfriend of the defendant in this case, and she went over to his home to give him breakfast before he got ready for work. And there was some verbal discussion about things that needed to be done. A verbal altercation ensued when she attempted to ask the defendant not to be insensitive when asking her to come over. She stated that at that time, when she attempted to grab her keys and leave, he snatched them from her and pushed her. And then she said she tried to get her keys again, and he pushed her onto the bed. And she got up from there and went to the closet where he was. And then he pushed her into the seal of the closet. And I guess her face hit the door, and it caused her to have a black eye. She did report this incident at the Zone 4 precinct to officers. And just for the record, I do believe this incident did occur on June 9th, 2022. We have some concern about the risk of offense given that there was a relationship between these parties. We do have some concern about intimidation given that relationship status between the parties and the fact that when she attempted to leave the defendant, he pushed her so hard that she ended up getting a black eye. Our victim advocate was not able to make contact with the victim in this case. Even still, Your Honor, given the intensity of the offenses alleged and the injuries that occurred to the victim, we're going to be requesting a $3,000 surety with no further contact with Lauren Banks. 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law.
Okay. PD Kim.
Yes, Your Honor. Mr. Phillips is 24 years old. He was born and raised here in Georgia. Your Honor, they broke up about 7 or 8 months ago, ever since June 9, 2022, there has been no relationship, and he does not have any interaction with her. They live separately. They don't have any children. Your Honor, I don't think my client has any intention to intimidate Miss Lauren Banks, who probably changed the phone number because I tried to call that number too. Nobody was answering the phone. I think that number is actually disconnected. Your Honor, my client has no objection to no further contact with her. And 3240 Verdant Drive is actually my client's place. So incident location is home address of my client where she does not reside. She has never resided there. He is gainfully employed at Apple Store as a retail agent. He's been continuously working there. He successfully graduated from high school, and he's a very bright young man who's trying to have his life together. This happened a very long time ago. We would like to request for signature on bond so he can focus on being a better citizen. Thank you.
And I just want to clarify, the state is not requesting a stay away. We're just asking for no further contact, given that he pushed her into a door and gave her a black eye. Nothing further from the state.
All right. I'm going to order a $3,000 signature bond through pre-trial or monitoring per the judge. I'm going to order no further contact with Lauren Banks. No drugs, alcohol, or weapons while on bond. And is that it? Because there's no stay away, right?
Would you only be inclined to add an anger awareness since it's a signature?
Oh, yes, one-day anger awareness class.
Thank you.
Yes.
Position 22, Mr. Robinson.
This is 23 CR 001256G. Ryan Robinson. You're charged with 1 count of battery family violence. I'm sorry, 2 counts of battery family violence. Offense date is December the 3rd, 2022. Pre-trial?
7 cycles, 4 convictions, criminal trespass 2016, theft by deception 2016, driving my license suspended 2020, and then it was a probation violation in 2017. Nothing further.
Mhm. All right, state.
Your Honor, these offenses did occur on December 3rd, 2022 at 2124 Cheshire Bridge Road Northeast in Atlanta, Georgia. The victim in this case is Andriana Richardson. I have it as ANDREIANNA. Richardson, common spelling. It's indicated that on this occasion, Your Honor, the defendant and the victim who share a child and live together were in a verbal altercation about who was going to watch their child. And the defendant got upset when the victim pushed a cup off the table and struck her in the face, causing redness. The state here has a concern about the likelihood of positive response to the legal process. The defendant does have a probation violation from 2017, revocation. We do have some concern about intimidation of this particular witness, given that they have a child together and they still share a residence. We're able to make contact with the victim. However, she indicated that she does not want to prosecute, but given the cycles of violence, the state would be requesting in this case a total $7,000 surety. That's $3,500 per charge. No further contact with the victim in this case. Third-party child transfer. Stay away from the incident location as they both live there. 1 day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. And I just want to make it clear to the court that there are 2 warrants and they have the same facts. However, both of these warrants were taken out on different days. One was taken out on January 26, 2023 at 10:19 a.m. and that was signed by Judge Wolf. And the second one was taken out on January 25th at 9:25 a.m. signed by Judge R. Williams. So the state at this time does not know if these charges are indicative of 2 separate instances of slapping the particular victim or are duplicative. However, we will find out with further investigation, but given what we have now, it appears to us that these may be separate and distinct instances of slapping this particular victim in the face with his hands. Nothing further from the state.
All right, PD Kim.
It seems like there's Miss Adriana Richardson. May we please hear her first?
Okay, Ms. Richardson, would you like to address the court today?
Yes.
Okay, let's see if I can hear you. Say something again.
Can you hear me?
That's a little better. Would you like to address the court today?
Yes, ma'am.
All right, let me swear you in first. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down. Are you in fear of Mr. Ryan Robinson?
No, ma'am.
All right. And you, I understand you all share a child together?
Yes.
How old is your child?
He's 6 months.
6 months, okay. And and you want to continue to reside with him?
Yes.
Okay. Any cross-examination by the state?
Just one question, Ms. Richardson, on the dating question, December 3rd, 2022, did the defendant in this case strike you in your face?
It was more like a smudge in the face, not like a smack. across the face. It was like a, I don't know what to call it, a smudge, I guess.
I'm sorry, one more question. Who called the police as a result of this incident?
I did.
And why did you feel the need to call the police on that day?
Just so that it wouldn't escalate any further. I mean, I don't think it would have, but at least to calm down the energy in the room.
And do you remember reporting to officers that he struck you at that time?
Yes, ma'am.
Thank you, nothing further.
PD Kim?
Nothing further, Your Honor.
All right. You can mute yourself, Ms. Richardson. Thank you for your time. Go ahead, PD Kim.
Yes, Mr. Robinson is 29 years old, and they have been dating, I believe, for about 4 years. Mr. Robinson is actually, he was born and raised here in Georgia. He has a family members here, his grandmothers and everybody. Your Honor, we would like to request for a signature on bond and also no further violent contact so they can continue their relationship. Incident happened a while ago. There has been enough cooling period that both of them are not afraid of each other. They want to live together. They want to take care of the child. So I think that is very reasonable to have a no further violent contact. And Mr. Robinson is gainfully employed as an electrician, and also he successfully graduated from high school, and he will be continuously taking care of Miss Adriana Richardson and his child. Thank you.
And who resides? I meant to ask Ms. Richardson, whose main residence is at 2124 Cheshire Bridge.
It's indicated they both live there, but Ms. Richardson may answer. I think she's still here.
Ms. Richardson, is your name?
Yes.
Go ahead.
No, my name is on the lease.
Okay, and his name is not?
His name is, mine isn't.
Which is it? Your name is or isn't on the lease there?
My name isn't on the lease, but his is.
Okay. All right. I am ready to rule. I'm going to order a $5,000 surety bond. I'm going to order Mr. Robinson to stay away from this location, 2124 Cheshire Bridge. I'm going to order, due to his history, based on the history and the allegations, I'm going to order that he have no further contact with the victim, Adriana Richardson. If there to be visitation with the child, that it be by third-party transfer. And I'm going to order a one-day anger awareness course as well. And no drugs, alcohol, or weapons while on bond.
Judge, what's the breakdown?
Oh, the breakdown is $2,500 for each.
Thank you.
Thank you.
All right, thank you.
Position 24, Mr. Red DeVille.
All right. 23 CR 001262Y, Michael Redveld. Not sure if I'm pronouncing it right, so I apologize for not doing that. You're charged at 4 counts. 1 count of failing on proper U-turn without a signal, I think, or failing or improper something turn without a signal. Expired or no registration or title. DUI under the influence of alcohol, less safe. and DUI driving under the influence of alcohol with 0.08 grams or more within 3 hours or more. All with the offense date of March the 6th, 2023. Pre-trial.
One prior from 2009 for possession of marijuana. There's no disposition.
Okay. State.
Yes, Your Honor, this offense did occur this morning at about 12:46 a.m. So March the 6th, 2023 on Georgia 140 near Georgia 400. This defendant was driving through several lanes on Georgia 400 in a Subaru without using a turn signal and weaving through traffic. At that time, officers initiated a traffic stop. And when they made contact with the defendant in this case, his eyes were red and watery, his speech was slurred, and the officer detected an odor of alcoholic beverage on the defendant's breath. At that time, the defendant did admit to officers to consuming multiple alcoholic beverages prior to driving. And the officer conducted standardized field sobriety evaluations, which did in fact indicate impairment. The defendant also blew into the Intoxilizer 9000, and that resulted in a 0.157, which is almost 2 times the legal limit. Furthermore, the car that the defendant was driving at the time of this incident had a registration that had expired on January 11th, 2023. Your Honor, as the court well knows, driving while impaired is very dangerous to the driver and other motorists on the road, especially given the fashion in which this defendant was driving. We have serious concerns. It's for those reasons the state is going to be requesting a $6,000 total split bond. That's $500 on the failing to use a turn signal, surety, $500 surety on the expired registration, $2,000 signature on the DUI less safe, and $3,000 surety on the DUI per se. No alcohol, drugs, and weapons, and no further violations of Georgia law, as well as no driving.
And with that split breakdown that the state is recommending, that was a 500 surety on count 1, 500 surety on count 2, and what was 3 and 4?
3, the DUI less safe is a $2,000 signature, and 4 was a $3,000 surety.
Okay. All right, PB Kim.
Yes, Mr. Michael is 33 years old. He was born in Maryland, and he has been living here in Georgia for the last 15 years. Your Honor, he graduated from high school, and then he studied biology at Georgia Tech. He has a bachelor's degree, and last 2.5 years, he's been working as a cook at the restaurant in Roswell, Your Honor. This is the first incident. We would like to request for a signature on bond, and yet we do understand how DUI rarely gets any signature on bond. So we would like to request for split bond, 500 signature on bond through jail, 500 signature on bond through jail, 2,000 signature on bond, and DUI, $1,000 good bond. Thank you.
All right. I will grant the split bond. And with that split, the first charge, $500, $500 signature bond. And the second charge, a $500 signature bond. So that'll be 1,000 signature through the jail. And then with the DUI, that will be a $2,000 surety on the less safe. And then a $2,000 surety on the other. So that'll be 4,000 surety and 1,000 signatures. Is that right, Miss Bridgewater?
It
You
is.
keeping up with me?
Yes,
Okay,
I am. It's a total $5,000 split bond.
right. I think I said 6, but I meant 5.
Okay.
Mm-hmm. And no drugs, alcohol, or weapons while on bond, and no driving unless you have a valid license with DDS. And I think that's it. Anything else, council?
Nothing further, Your Honor.
Nothing further.
All right.
from state.
Position 25, Mr. Wilcox.
All right. 23 CR 001265C. Michael Wilcox, 1 count of criminal trespass. Offense date is March the 5th, 2023.
Everybody who's done.
I'm sorry.
Don't forget your hat, whoever that is.
Go ahead, pretrial. That's Michael Wilcox.
87 cycles. I'll summarize as best as I can. I saw
Okay.
at least 6 FTAs, at least 15 probation violations, at least 15 criminal trespass convictions from 1993 to 2019, a robbery conviction in 2015, terrorist threats conviction 2016, possession of cocaine 2011, robbery 2010, simple battery 2013, 2010, 1998, aggravated assault 2006, failure to leave a facility conviction 2009, simple battery against a police officer and willful obstruction 2005, simple battery 2007, 3 disorderly conducts 2019, 2011, 2001, and then some 1990 convictions. Would you like those?
No.
Okay.
All right. State.
I also saw that this defendant does have an open case in Superior Court. It's 23 SC 185742, which includes criminal damage to property in the second degree, 4 counts. And this defendant at that time for that case is out on a current UJR with pretrial wraparound. I counted in his record as pretrial stated at least 6 criminal trespass convictions in the past year alone. And I think it is worth note for the record that those convictions all occurred at stores in the Lee Street area. The incident before the court today did occur yesterday at the Texaco located at 1117 Lee Street Southwest. The defendant returned to that location after being previously criminally trespassed from that location by the officer that responded to the incident on September 7th, 2022. Given this defendant's extensive history with criminal trespass, as myself and pretrial have reiterated, and this defendant's history with probation violations and FTAs, we have concerns about flight risk, and we have some concerns about this defendant's likelihood to positively respond to the legal process, given that he has such an extensive history with convictions of this nature. The state is going to be requesting a $1,500 surety bond and stay away from that Texaco, no alcohol, drugs, and weapons, and no further violations of Georgia law.
All right. PD Kim.
Yes, Your Honor. Mr. Wilcox is 53 years old and he has a mailing address. However, he is residentially challenged. So I am requesting social worker services so that way he can get some housing resources. He does not have a phone. So I think that's why we have to have a social worker service. They have to visit and help him out. Your Honor, his highest level of education was 10th grade in the high school. After that, he has not had lengthy employment. I'm also asking for BHET done by a social worker just to make sure if there's any issue. Thank you.
All right. I'm going to order the $1,500 surety bond. Gonna order stay away from the Texaco at 1117 Lee Street Southwest. No drugs, alcohol, or weapons while on bond. BHET. B is in boy. No drug, I said no drugs, alcohol, weapons. Anything else, counsel?
Nothing further, Your Honor.
Nothing further from the state.
All right.
When am I coming to court?
The reset date is March the 21st. If you don't make bond before then.
Position 1, 2, and 3 on the add-on. Mr. Stoller.
Hello, guys. You're on. Hey, Joe. Ladies, I guess, today.
All right. I have the first two, and I'm sorry I haven't been able to print out the third one. I'll let you read the third one for me, Ms. Bridgewater.
Okay.
The first two are with Matthew Stollard, case number 23CR001275C, one count of theft by services on March the 5th, 2023. Second case 23CR001276C, and that is again theft of services on February the 20th, 2023. And what's the third case?
Third case is case number 23CR001277C, theft of services. However, I don't have the date of the offense. Can the state give it to me?
Yes, so we have for one offense, February 27th. For the next offense, we have February, excuse me, 20th. And for the final offense, we have February 21st.
Oh, now I have a March.
Oh, excuse me. Yes, Your Honor. I'm sorry. I'm conflating that with his currently open theft of services. So we have February 20th, February 21st, and March 5th.
Okay.
That is correct.
Okay. All right. Go ahead, pre-trial.
4 cycles. He appears to have an open case for theft of services from February 27th of this year. However, I do not have that case number written down, and he has one conviction from 2012 for knowingly driving a motor vehicle on suspended, cancel, or revoked registration. And nothing further.
All right.
And Your Honor, I do have that case number. That case number is going to be 23CR. Let me see. Just a moment. 23CR 001148C.
All right.
Okay, so Your Honor, on that case, the 00148C, 1148C, the state of Georgia actually agreed to, and I actually handled this case, a $1,000 signature bond with Judge Morrow on February 28th. The defendant bonded out on that case and then picked up a new charge on March 5th of this year, so yesterday, with basically less than a week between incidents. He picked up a new offense at, let's see, Lucy's Steakhouse, which is interesting because his last incident was at Cabernet Steakhouse, so he appears to have quite a thing for steak, I guess. At this location, the defendant actually consumed $56.04 worth of food and beverages, at which point he then failed to pay for those items and then left the establishment without paying. The restaurant manager did positively identify him, and when he was asked about his bills, he stated he had paid but could not provide any proof of payment, at which point he was taken into custody. There were also apparently 2 outstanding cases where the warrants were taken out after his first arrest, but before his second arrest. And those both happened at the original Pancake House at 5530 Windward Parkway for, I'm sure you can guess, not paying for meals. One was $20.38 worth of food and beverage, and one was $23.67 worth of food and beverage. And again, the manager identified this defendant as the person who failed to pay on both dates, the 20th and the 21st. I'm not 100% sure what's going on here. I don't know if this is something that we may need a social worker to assist with, because this seems to be a pattern that has just emerged and does not seem to be slowing at all. So for those reasons, the state would ask for a $1,500 surety bond. We tried the signature bond route, and it kind of tended to bite us on that one. So we are asking for $1,500 surety, $500 on each offense. We are also asking that he stay away from the original Pancake House and Lucy's Steakhouse. He is not welcome there, and they do not want a non-paying customer to be eating at their establishment. So we are asking for that. Stay away, no alcohol, drugs, or weapons. That's all.
All right. PD Kim? Oh, you're on mute.
Oh, Mr. Matthew Stollard is 48 years old. He was born in Tennessee and he moved to Georgia in 1999. So he's been here for a while. He has been staying at Hampton Inn near Highway 400. So I would say he's residentially challenged. So I'm actually asking for social worker services to have a visit, so that way he can provide housing services, housing resources. He does not have anybody who can bail him out. Unfortunately, he has no emergency contact. He has not had a job for last 5 months. Before that, he was a professional musician, and he graduated from high school. He went to college for 1.5 years, but he does not have any kind of income at this point. So he's qualified for public defender services, and we will continuously provide our legal services. So since he has nobody else to bail him out, we would like to request for a signature on bond. And yet, if Your Honor is not inclined to give him a signature on bond, we ask for $1,000 good bond. Thank you.
All right, I'm going to order the total of $1,500 surety bond. That would be $500 on each of the 3 cases. The surety bond for case number 1, $500 surety bond for case number 2, and $500 surety bond for case number 3. I'm going to order a stay away from Lucy's Steakhouse and a stay away from the original Pancake House. And then there were 2 from the Pancake House, right?
Yes.
That is correct, Your Honor.
I
And
was thinking, did I have a 3rd address, but I don't.
Oh, no.
I guess, well, the other one would be the steakhouse, and I'm just going to say, we understand, Mr. Stollard, we're going to order a BHET so that the social workers can see you to provide some resources, but you got to stop doing this because you're just rolling back and forth through the jail for eating at establishments, being embarrassed to be escorted out because you've not paid for your services. So I need you to just promise me that you're going to stop doing this, but they will find some resources for you so that you can get a meal without having to be accused of stealing the meal. And I'm going to order you to stay away from those places or any other establishments. Stay away from any restaurants or stores where you are not able to pay for your services, your items, or the food that you may eat at these locations. And on all 3, no drugs, alcohol, or weapons while on bond.
In Your Honor, I just wanted to give the addresses for both those locations. Lucy's Steakhouse is 5805 Windward Parkway in Alpharetta, and the original Pancake House is 5530 Windward Parkway, Alpharetta.
All right, anything else?
Nothing further, Your Honor.
Nothing from the state.
All right. Is that all of our cases?
I think number 9.
We
Did they
have
break
5.
out?
I thought number 9 was a, oh, go ahead.
Your Honor, I still have 2 cases left.
Position 5 and 9.
Taylor Collins and Goodrum.
They're both waived their appearance.
Pardon me?
Good one was a medical research.
Goodrum?
What about Collins?
Taylor Collins, I waived her appearance, Your Honor.
Oh, you waived appearance on Collins?
Yes, Your Honor.
Okay.
In courtroom 2, I just wanted to confirm because number 13 was listed as a medical reset. So you're saying number 9 is a medical reset as well?
Yes.
Okay.
What was number
Okay.
9?
9 was going to be a breakout, but it's a medical reset.
Oh, I filed a, wait, which one's 9 is, I'm sorry, I'm tired.
9 is Goodrum.
Yeah, I filed a waiver of appearance and a psych evaluation
Oh,
for competency.
Did you send it over to me?
I asked, I forwarded it to Ms. Kim. Did you forward it?
Oops, sorry. I have not checked it. Let me check right now.
Then also I'm showing that position number 5 was NOD. Is that not true?
On one of
No,
her
she
cases,
just
wait,
said
that
she waived.
Collins, she had the theft by shoplifting.
I don't know.
Miss Bridgewater, I think what occurred on that case is we had one case was NOD'd. The
Yes.
other case we are going forward on, and that's the theft by shoplifting.
Ms. Kim, do you see it or do I need to re-forward it to you?
Would you please read forward because I don't see it?
Okay, I sent it at, let me see.
So the criminal trespass on 5 was NOD.
No, that's incorrect. There was a full separate
sorry, I'm
case,
sorry.
a simple battery that was NOD that
Oh,
is
okay.
completely separate from these 2 charges.
Gotcha.
Are we going forth with position 5?
Yes, ma'am.
Okay.
Stays ready.
Okay, do you have them now? Wait a second. I'm sorry, we're all talking over each other. I'm sorry. Ms. Kim, do you have those? I just sent them to you. I sent it at 12:52, the 2 waiver of appearances and the psych eval. I already sent it to you. that it?
Was it J dot, okay, I just got it. Yes, yes.
Okay, can you forward? I didn't know who to forward it to.
Okay, I'll forward. That's fine.
So those are, so I think on the, Miss, since I did waive her appearance on Miss, Goodwin, we still need to set her bond. I'm asking for a competency eval. She was at the jail earlier, so I don't know why there was a medical reset.
Judge Mancy, can you check the chat, please?
Who?
So we are going to hear position 9. You did the waiver.
I just forwarded to Miss Holly Bridgewater.
Okay, let me see what's going on.
Thank you.
Yes.
Okay.
All right, thank you.
Can we go ahead and set a bond up for Goodwin?
Thank you.
Uh-huh.
Because I did ask for evaluation.
I thought it won't let me answer. I saw something where it said it disabled something for me. Who's my host again?
Oh, Miss Strong.
I'm doing it now.
Okay. Because I was trying to answer Ms. Roberts in the chat, but I can't.
So I have those 2 left. Do we want to go ahead and set a bond for Goodwin?
Mr. Jordan, hold on a second, Ms. Milner. What did you say, Mr. Jordan?
You should be able to just click on the chat button at the bottom of the screen.
Yeah, but I'm in it and it is still just saying, okay, maybe because she's
Then
already
click on
gone.
everything. Oh,
Yeah, it could be.
dropped off. That's probably why.
Okay, she's logged off now, so I can't, I was saying, okay. State, you'll have to give me the histories on these last couple.
Yes, Your Honor. I have the history on Collins.
Okay. And you just have that, Ms. Bridgewater? Did you
I
just
thought we were
get
doing
those?
Goodwin first. I'm sorry.
Hold on a second.
Oh, wait a
Bridgewater,
minute. Let me
did you
see
just
what's
get
going on.
those?
Okay, hold on 1 second. Okay, I just printed the evals. Let me see something. Okay, Judge, what are you asking me?
Oh, well, I received them and I usually receive them through you so that you'll have
I
them
just
in your.
got them, so when I
Okay.
send over the orders, I'll give it to you.
Yeah, and just send them in the future, just send them to Miss Bridgewater. You send them to me, I will, who knows, but Miss Bridgewater, that way she'll send them to me as a stack, as a group.
And
So
I'm
that I
sorry,
can keep
I sent it to
everything.
Miss Kim at 12:52, and it's my fault.
Oh, it's okay. All right, now we'll start with position 5, which is Collins.
Yes, Your Honor.
Okay. And
And
that's
you're-
PR 00127J. And this is Taylor Collins. I've had a waiver filed. And is that, I don't know if it's a male or female. Taylor, female, being charged with 1 count of theft by shoplifting and a 2nd count of criminal trespass. So
Yes,
that's
Your
what
Honor.
we have. Okay. State, go ahead.
Thank you, Your Honor. The facts are that on the incident date of December 5th of 2022, at the Walmart located at 970 Mansell Road in Roswell, this defendant did walk in that Walmart and she went to the shoe department and she took the boots that she was wearing off her feet, placed them on the shelf, and then proceeded to place a new pair of boots from the Walmart on her feet and walk away. She's also seen on surveillance video grabbing a pair of tennis shoes from the shoe department at the Walmart, as well as other merchandise. The defendant was eventually confronted by loss prevention. And at that time, she became agitated with loss prevention and she refused to provide her identification. She also left the scene before the police could even come. At the time of that particular incident, there was a criminal trespass warning or a criminal trespass in place from Walmart that was instituted on July 16th of 2016, and it was still active in 2022 on the date that she stole these items from Walmart. The defendant's history includes, in Georgia, 3 cycles, a 2018 conviction for DUI, a 2016 arrest for battery, family of violence. That was NOD this morning. And we also have her Florida history, which indicates a 2020 arrest for fraud, a 2021 arrest for passing a forged bank bill, and a 2022 arrest for grand theft larceny. In light of her recent history in Florida for theft, looks like I mentioned at least 3 theft-related offenses. The state is concerned about this defendant's risk of reoffending, so the state's recommendation for bond is a $2,000 surety bond, $1,000 each on the theft by shoplifting and the criminal trespass, as well as no alcohol, drugs, or weapons while on bond, and to stay away from the Walmart at 970 Mansell Road in Roswell. Nothing further.
Yes, Your Honor. So I understand that she had some thefts, and obviously, usually when there's around thefts, there's usually a drug problem. But if you notice, this was in December. She is employed with ARS, and she's a marketing manager, so she has insurance. She was just released from Black Bear, the treatment center up in North Georgia, the accredited one by GAR. And we're asking for a signature bond on these cases. I know her history is recent, but she's waiting to get into Talbot House. And because she is on leave, she does not have any of the financial means, but she is, she's been trying to get help for her drug problem. And we're trying to, trying to encourage the court to let her continue to get the help she needs, and by going to Talbot House while her insurance can still pay for it. But if you look at Black Bear, that's one of the top cover residences in Georgia, right behind Ridgeview.
And the status for Talbot?
She's waiting on getting a bed, Your Honor.
Waiting on a bed.
Right.
What do we think the likelihood? Because if I give her a signature bond and she gets out but doesn't go there, or do I give her a signature and the only way she can get it out is, are they coming to pick her up? Is somebody taking her? Because we've had those in the past.
I do understand that, Your Honor. But I would ask for a signature bond on this one. I'm just trying to get her.
Never makes it there. That's my only concern. And the jail is not going to sit and hold them and wait till they come.
Right.
We're ready to let her go. Then she may be out there and not make it to the Talbot House.
Right.
Usually sometimes they'll say they've already gotten the transportation arranged or something like that, or.
There's not a bed open yet. And because I don't have an ROI, I couldn't follow up on it.
You know, my inclination is to give her a surety bond until you get a bed and make sure, and then when you do, and bring it back or send it to Mr. Jordan and I'll sign it to give her a signature bond, knowing that they have a bed and she's ready to go there.
I think it's gonna be, without the ROI, it's gonna be hard for us to get it set up. Because I'm in the mental health court and the DUI treatment court, and these facilities, and I understand what your court is saying, I absolutely do. It's just my hands are tied with getting information. And I don't want her to get lost in the jail. We don't want that.
Does the state have any
I know what they're
big objections and concerns?
Yes, I do object to her being released on a signature bond unless it's going to be directly into that program. And that's in light of the fact that even when she was arrested for this case at the Walmart, she was belligerent with the loss prevention officer and told the officer, you can't hold me here, basically, and left the Walmart before the police could arrive. And the reason why we NOD'd her 2016 case is because she's been on the run since 2016 for the battery family violence. So we ran afoul of the statute of limitations. So the state does have concerns about Miss Collins showing up and taking accountability for these cases that she's accumulating here in both Georgia and Florida. So the state would definitely object to her getting a signature bond at this time until that period.
I'm sorry.
That would be
I'm sorry.
Okay, well, thank you, but I was wanting to finish my sentence.
I know, I said, I'm sorry. So why don't you finish it?
Okay. So yeah, the state would object to that for those reasons. Thank you.
Are you done now? Okay. So
yes, I am. Thank you.
Yeah, I don't take offense to the state's statement that she's on the run. She lives in Jacksonville. That's where she's originally from. So and she's like marketing manager there. She's and she has still has the insurance. And that's why I'm sort of in that time crunch, because I know how expensive these treatment programs are.
Well, I'm going to, based on her history and kind of what I've heard here today, I'm going to give her the $2,000 surety bond for now, and bring it back around or let us know once we have confirmed that she has a bed. And I know what you're saying, you need the ROI to get her in, but her history is just kind of not there. And I'm going to defer right now to the $2,000 signature bond, but $2,000 surety bond, $1,000 on each. Stay away from the Walmart at 970 Mansell Road, and no drugs, alcohol, or weapons while on bond.
Okay.
And if you need to get me an order, Mr. Jordan will certainly get it to me, and I would reconsider and sign it once we confirmed.
Okay, yes, Your Honor. And I think the last one we have is Goodrum.
Position 9.
This is 23 CR 001257C, Joyce Goodrum, charge of 1 count of criminal trespass. 3/4/2023. State, what do you have for the history?
Your Honor.
I'm sorry, Your Honor, is pretrial still on the line?
No, she had something she had to go attend to. So that's why I was asking the state what they had.
Your Honor, I was just going to say, Mr. Young is going to handle this one. However, I would ask that we either adjourn to a breakout or turn off live, since we are going to be discussing MH issues.
Okay. All right. I keep forgetting my Zoom master. I'm terrible. Miss Strong.
I think it's I think she left.
She had to go.
I think it's Mr. Jordan now.
Mr. Jordan.
There he is.
Hello, Mr. Jordan.
Did you want to do the
turn
breakout?
on the recording?